One. One, two, 1, 2. Good morning, all. I just want to make a quick announcement, or actually it's a reminder of the protocols in place for this auditorium. Importantly, number one, there is a red line on both sides of the auditorium in the aisles. No member of the public or the media is allowed to cross that red line. Secondly, members of the public, you are to confine yourselves to the public gallery. The benches in between that aisle up there, just below the public gallery, and the front here is reserved for media and legal representatives, the legal teams. So please respect that. Members of the public, please do not come down into the media and legal area. And yeah, we will be starting shortly. Please make sure that your cell phones are off or they are on silent. If you need to work, put them on silent. Make sure that they don't ring and disturb the proceedings in the process. All right, it is 29 minutes past 9. We are about to start. Please stand. Thank you.
Longer than usual, Mr. Michaels. Good morning, Mr. Log. Good morning, Ms. Hassim. Good morning. Please place your name on record. My apologies. But good morning, so long.
Good morning, Chair. I'm Advocate Missy on behalf of Mr. Matlala.
Sorry?
I'm Advocate Missy on behalf of Mr. Matlala.
How do you spell the surname?
Missy, M-I-S-S-I.
Oh. And good morning to you too, Mr. Matlala.
Good morning, Chairperson.
Thank you. Who do I look to or at?
I will address the Commissioner's Chair.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next,
Call at his last appearance, his legal representatives intended to move an application in terms of which they sought to assert certain of his constitutional rights.
One. One, two, 1, 2. Good morning, all. I just want to make a quick announcement, or actually it's a reminder of the protocols in place for this auditorium. Importantly, number one, there is a red line on both sides of the auditorium in the aisles. No member of the public or the media is allowed to cross that red line. Secondly, members of the public, you are to confine yourselves to the public gallery. The benches in between that aisle up there, just below the public gallery, and the front here is reserved for media and legal representatives, the legal teams. So please respect that. Members of the public, please do not come down into the media and legal area. And yeah, we will be starting shortly. Please make sure that your cell phones are off or they are on silent. If you need to work, put them on silent. Make sure that they don't ring and disturb the proceedings in the process. All right, it is 29 minutes past 9. We are about to start. Please stand. Thank you.
Longer than usual, Mr. Michaels. Good morning, Mr. Log. Good morning, Ms. Hassim. Good morning. Please place your name on record. My apologies. But good morning so long.
Good morning, Chair. I'm Advocate Missy on behalf of Mr. Matlala.
Sorry?
I'm Advocate Missy on behalf of Mr. Matlala.
How do you spell the surname?
Missy, M-I-S-S-I.
Oh. And good morning to you too, Mr. Matlala.
Good morning, Chairman.
Thank you. Who do I look to or at?
I will address the Commissioner's Chair. As scheduled, we continue today with the testimony of Mr. Matlala. The Chair will recall at his last appearance, his legal representatives intended to move an application in terms of which they sought to assert certain of his constitutional rights. It was agreed that that application will be in writing. That application and its argument will be dealt with by Ms. Hassim, and at the conclusion of which I will then proceed with the testimony of Mr. Matlala. Thank you, Chair.
Thank you.
Thank you, Chair.
Yes, Ms. Hassim.
Chair, we are here to start the morning's proceedings at the behest of the legal representatives for Mr. Matlala on the basis of an application that they brought on the 21st of August. As the Chair and the Commissioners will recall, there was a very strict time frame that was issued for the delivery of pleadings in that application.
Was it in this matter that for the first time I even said there should be no slippages, or was it in another matter?
It was in this very application, Chair,
yes.
In which you emphasized that there will be no slippage, and you were precise about the time at which the various pleadings and heads of argument ought to be filed. So we have, as the evidence leaders, there was an affidavit filed. Not on time, on Saturday. It was 45 minutes late. The evidence leaders responded to that by means of an answering affidavit that was filed according to the schedule.
Was there an explanation, even if informal in the sense of a letter as opposed to perhaps an application for condonation? I've not seen an application for condonation, but at least an informal explanation, say by letter, for example,
Chair,
for their lateness, for Mr. Matlala's lateness.
What I'm advised is that there was a delay in obtaining the signature from Mr. Matlala. We then requested the unsigned version. So what was 45 minutes late was the unsigned version. We don't know why that could not have been provided on time, because it was the unsigned version with the later to follow. The later signed version came much later in the day. We don't have any further explanation for it, and my learned friend will no doubt have to address the chair on that. But just to put the order of events in context. This is in the context of the ruling. The evidence leaders then filed the answering affidavit, which was due at 10 o'clock on Saturday morning. That was duly filed. The second aspect that we were required to address was heads of argument based on the application. Those heads were due at 6 p.m. on Saturday. They were duly filed at 6 p.m. on Saturday. What we did not receive by the evidence leaders, what we did not receive was the replying affidavit from the representatives for Mr. Matlala, which was also due at 6 p.m. on Saturday, nor did we receive heads of argument. We've not got an explanation other than a letter, and Chair, if I may take you to that letter. I'm not sure if it's in your correspondence bundle or if it is provided to you separately. It's a letter that was provided on Saturday at 5:05 p.m.
But if it's the letter that, amongst others, says Ms. van den Heever could not attend the consultation, she was not well, and also talking about the replying affidavit and written submissions which were not filed, we have had sight of it.
That's the letter I'm referring to.
Yes.
What we understood from that was that there was still a consultation to take place with the client, and that we would receive the replying affidavit or the heads at some point on Sunday. It never arrived. I must also say that the heads of argument, of course, are not dependent on the consultation with the client. The heads of argument could have been provided. As we sit here, we do not know what the legal basis is for this application, other than broad assertions of the privilege against self-incrimination and what we've seen from the affidavit, that they wish to rely on a challenge that they intend to bring in the pending trial in relation to the chats and the recordings as being unconstitutionally obtained evidence. I'm not going to stray into the merits of our opposition to the application at this point, Chair, because I'm jumping the gun. My learned friend must address you first. All I want to do to begin with is to place in context how we are sitting here before you today, which is we have filed our answering affidavit and heads of argument. We've received nothing from my learned friend. And we've not received a condemnation application or a postponement application.
All right, all right.
And I think once my learned friend addresses you on the merits, I can then turn to the merits.
Thank you, Ms. Hassim. Ms. Missy, let me start by correcting myself before you address us. I gave instructions very early this morning that a directive be sent out that in the event that a postponement is not granted, I direct that only 30 minutes of argument will be allocated. I referred to a postponement because of an erroneous recollection of the contents of the letter that Ms. Hassim has just referred to. My memory, which was a lapse, was of the view that that same letter also sought a postponement. My co-commissioners this morning corrected me and said the letter does not seek a postponement. So I thought I should, in case my directive created confusion, just correct myself up front. But I must say this, if we get to the point where the application has to be argued, my directive as to time allocation stands. Let's hear you.
Thank you, Chair. I've considered how I would address the Commission with regards to this, and I deem it important to refer to a folktale that I've often heard in the corporate world. And the story goes that a security guard was once informed that the boss or the CEO of the company has given instructions that before 6 a.m., no one ought to enter the building. And the said CEO, on another day, attempts to enter the building before 6 a.m. And what he's told by the security guard is that, boss, umthetha uvumi. You will not enter here. I was told that you do not enter before 6. It does not matter whether you are the CEO or you are the one that gave the rule. I will not open for you. And I proceed with that because I want the commission to get a proper understanding upon which the entire team of Mr. Matlala labors under. Correct. One would note, as correctly put before the commission by Ms. Adila Hasim, that we did endeavor to provide them with an unsigned affidavit 45 minutes late. That's correct. It then took us approximately 3 hours to file our subsequent signed affidavit. Logically, as an individual, a layperson sitting anywhere would wonder to themselves, but if you had an unsigned affidavit and you only needed for your client to consult, make whatever changes you needed to make, why would it possibly take you 3 hours for you to then get a signed affidavit that's commissioned and file it and serve it on the evidence leaders? And that should give you a picture of how difficult it is for you to get access onto the premises, to get driven from your entrance as a visitor all the way into CMEX. When you enter the entrance at CMEX, how long you have to wait to get searched to complete the forms for you to then get taken from that point and walk into CMEX, where you also at that point have to wait for somebody to come and take you up to the boardroom that we have fortunately been allocated by management within CMEX. You then are in there, you're not allowed to have your cell phone devices, which in this day and age, that's what we primarily depend on to get access to the internet. With that being said, we would then have to go through the affidavit. You go through the affidavit, you make the changes. You now have to call said individual to come back and to take you guys downstairs for somebody to open the door for you to get out. You are not allowed, and I actually have got a tongue lashing personally by the management of security at CMEX, informing me that I do not understand and cannot comprehend the level of security and risk that I'm putting myself under by wanting to roam around the CMEX prison without somebody there to guard me and to accompany me. I then was taken to another office where I had to wait for somebody to come and take me to walk out and go to the security with my learned friend, my instructing attorney rather. We then waited approximately 30 minutes to get a ride from CMEX all the way to the gate. We would be able to get access to our phones, get the internet, and for us to then, I apologize for that, and for him to then go and print the affidavit and then come back. That is a process on its own. We then have to start again, request for us to get a pickup to go back to CMEX, follow the whole process, somebody to pick us up as I had explained initially. And that on its own tells you the difficulty under which we have to labor to get an act that would ordinarily take plus minus 35 minutes to get done. But it took us almost double the time. Over and above that, we did indicate to the evidence leaders that we had an issue because our lead counsel, Ms. Van Hever, was the one who was scheduled to go and consult with Mr. Matlala. So on the way there, when they had received the replying affidavit, she was unable to consult. She turned back home. And by the time we were able to speak to her, I couldn't go back in. I'm then further instructed by I'm told by my instructing attorney that even when he arrived, he was not allowed to go and consult where we were allocated to consult previously. He was treated as an ordinary visitor. So all he could do was hand over to Mr. Matlala the answering affidavit rather, and explain to him his understanding of the legal issues and the position that we would take going forward. Mr. Matlala then gave him instructions that he would need to read the replying affidavit and he wants to consider the limited advice that he has received from the instructing attorney, and that he also wants to hear the position that is being taken by us as counsel. And again, you note, we don't have cell phone devices. He does not have access, rather, to a computer where we could possibly send him an email and maybe in the evening he could quickly just see what it is that we've said, and maybe then, before we arrive, he would have a position and we could proceed. On Sunday, Ms. Van Hever then gives me instructions to go with our instructing attorney to attend to this consultation with Mr. Matlala. I personally attended to it. I had to grovel with the head of security and beg for him to at least give us 5 minutes to engage with Mr. Matlala so that we would be able to at least give him an idea where we stand, and then hopefully we can get some instructions. Over and above that, while we're at the prison, we then receive another affidavit from the evidence leaders, which they intend on using. That same affidavit I had to quickly give to Mr. Matlala to glanced through. He didn't even get an opportunity to read it and to give us a position, and we do believe that he has to address it in the replying affidavits at minimum.
Is that other affidavit the one deposed to by the senior investigator, Mr. Dlamini?
That's correct, Chair. That's correct. And so with that being said, the limited time that we had while trying to balance getting information from Mr. Matlala and maintain relationships with the individuals that tomorrow we have to come back again and beg on a Sunday if necessary to give us access to him. We then had to respect the time that they had given us, quickly give him what we gave him, have him glance through the affidavit, at which myself personally, I had not read through, and I couldn't even give him an idea of exactly what is being said in the affidavit, except to say it was from the lead investigator and it has to do with a consultation that they heard on an earlier encounter with the evidence leaders, I believe. With that being said, we were unable to get instructions from him. The little information that we got required us to then create a strategy of how we'll move forward and still be efficient. And our conclusion was that the best way to move forward would be for the instructing attorney to go through the docket again, go through the Section 204 affidavit so that he can adequately provide evidence before, rather depose to an affidavit that is correct and properly represents Mr. Matlala. We have not been able to conclude that process, and as a result, we were unable to file our replying affidavit as we had intended to on Sunday, Chair. With that being said, from Saturday, Ms. Van der Heever has been sick. And I do believe in her first appearance on behalf of Mr. Matlala, at some point she intimated that she suffers from rheumatoid arthritis. That has put her in a position where she's so ill. I was engaging with her this morning. She can't use her hands or feet. She's with the doctor and they're consulting to see a way forward. But what she did guarantee me is that hopefully with the medication that she's receiving, by the afternoon, she'll be in a proper position where she'll be able to continue with us working and appear tomorrow to argue. So my instructions right now, having considered the fact that we are constantly being hit with umthetho awuvumi, you cannot do this or that, and we have to try and navigate the systems where ordinarily a layperson not sitting in this commission would think, well, these individuals are incompetent, or maybe perhaps they're trying to not come before this commission in good faith. That is not the position. You have to be in it to truly understand what it takes for you to properly represent Mr. Matlala, because he is not an ordinary witness that you have access to at 12 a.m. rather in the morning, or at 3 a.m. in the morning. We don't have that liberty before us. And I do know with regards to the additional bundles that we receive later on, they make it even harder because he wants to read. He wants to know what's being said there so that he can give us proper instructions moving forward. He's not in a position where he feels comfortable that it would be smart and wise for him, given the status that he holds outside of the commission, to say to the commission, well, I did say let's go ahead, without considering the implications that it would have on him. And we beg this commission, humbly so, Chair, to consider all the elements that we consistently have to deal with to try and ensure that we represent Mr. Matlala, and also stand before the commission in good faith, that we're given an opportunity to file that replying affidavit, our heads of argument, and as well as a written condemnation application for the late filing. Thank you, Chair.
Thank you, Ms. Missy. Yes.
Chair, just 3 points.
May I just raise an issue, Ms. Missy? What the evidence leaders answering affidavit raises is a legal question, or rather what it raises are legal questions, 100%. So I don't understand this issue of agonizing over how, when to consult Mr. Matlala with regard to a replying affidavit. Those are legal questions which would not necessarily have required Mr. Matlala. Those are legal questions that you, as lawyers, should have been able to respond to. Truth be told, actually, there wasn't even a need for a replying affidavit. You could just have put together written submissions, and you would not have been out of time. So I have difficulties understanding the difficulties that you say you had.
Chair, yes, to the effect that it relates to legal issues. But there's also information during their consultation, as limited as it was, where it became clear to us, having had sight of the replying affidavit, that there's factual elements that need to be addressed that relates to documentation which we did not, or rather they did not have at hand when they were consulting. To say to that, we received a further document this morning from Mr. Matlala that he was unable to go and obtain from his the room or the prison cell that he's been kept in. And it speaks directly to the issues that would have to address in terms of the legal points. So there's a special element
that's
to it
very
as well.
peripheral. Those issues about whether Mr. Matlala received certain documents a day or two before the hearing of his testimony, those are very peripheral issues, and they have nothing to do with the legal questions that Mr. Matlala's application raises. So I think my point stands.
Chair, I did not hear the last few words that you said.
I said I think my point stands.
Noted, Chair. Noted.
You are free to respond. I'm not a dictator.
No, Chair, I believe what I've set down in terms of the entire process and how we found ourselves here today I can't explain it any further than what I already have, Chair. And as I stated earlier on, I can only beg this commission to take into consideration and to give us a chance up until
I'm
tomorrow
listening. You
morning,
may
Chair.
continue.
Thank you, Chair.
Let me indicate what my inclination is, which you would obviously have seen in the directive that I issued. In fact, I sent it out to the attorneys after 6 a.m. I don't know what time they instructing them to write a letter to Mr. Matlala's attorneys. I don't know what time that email was sent, but I gave the instruction after 6 a.m. My inclination is for Mr. Matlala's application to be argued now, this morning. That's my inclination. What's your response to that?
Chair, my application for a standout from tomorrow, still, that is the position that we're taking. If the chairperson could grant us that opportunity to come before this commission prepared, and at least for you to have sight on paper, at minimum, some of the case law, because we do believe that this is an issue that has never been dealt with by any commission in South Africa. Speaking to the position that we find Mr. Matlala in, and we do deem it imperative that you have sides, yes, of the legal argument, but also the case law that we rely on to make out this argument. I don't know how efficient it will be, given that it's a constitutional issue and the position that we find ourselves in, and we've tried to look and research to see internationally if we could find something that could give us guidance on this here, on the issue that we intend on arguing. And we do believe that it would be of a benefit to the Commission to have sight of the case law and our written submissions, Chair. I don't know how beneficial it would be if I only argue this and you are unable to make reference to those cases and the paragraphs and see exactly, is she applying herself correctly? Do you agree with me, yes or no? And what's the position? And I think perhaps that's the consideration you'd have to make in finality, which is one, this is a position that we believe any commission here in South Africa has never had to deal with and answer and consider. And perhaps it would be beneficial to have consideration of the cases that we would like to refer to or refer the Commission to, Chair. Thank you.
Thank you. I will go back to the question that I asked about this being a legal question. This is something that Ms. Vandenheever was quite passionate about from the day of the last appearance. She referred a number of times to an application where points in limine would be raised. From the moment that you start thinking about bringing an application in which you are going to raise points in limine, you already know what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. Vandenheever, Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this the process that we have before us this morning, and underlined, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making, that perhaps what we could have done in the interim was prepare the heads of arguments to assist the commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight, and that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.
Yes, Ms. Hassim. Perhaps let me just ask this quick question of Ms. Sillo. How much longer do you think Mr. Matlala's testimony will take? I know those estimates have regularly been overshot.
I know, Chair, and in this case, it shall be particularly so because Mr. Matlala's testimony in truth hasn't even begun. So all he's done is read his statement into the record, which he has sort of supplemented through this application. I guess he may want to place that also on record. We had anticipated a minimum of 2 days after he has placed his statements on record, Chair.
So today and tomorrow?
Today and tomorrow. A minimum of 2 days. Thank you, Chair.
All right, thank you, Ms. Sillo. Yes, Ms. Hassim.
Chair, just a few responses to what Ms. Nisi has submitted. The first is, and just to correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. And I'm not going to repeat it because, Chair, you've made the point and Commissioner Khumalo has made the point. Those are legal, that's legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously, and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second point...
Please continue.
On the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in a commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about the judgment having been unanimous.
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's the judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Khumalo have already made, that this is something that's been brewing for some time by Ms. van den Heerfer. The third point is just in relation to, I just want to correct the Dlamini affidavit. It's true that the Dlamini affidavit was filed with the commission and submitted to Mr. Matlala's legal team this weekend. But that's not part of the application that's before the Commission today. It's entirely separate. And that should not hold up the argument on the application. Those actually are my submissions. Chair, I think that the Commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've set it out in the heads of argument, we wish to have the application dismissed, and we want the questioning of Mr. Matlala to proceed immediately because time is short.
Thank you,
Chair.
Ms. Hassim.
I'm sorry, Chair. There's one last point that I've forgotten, and it's sitting here in front of me. I'm sorry about this, Chair, but we also received communication yesterday, and this is something that perhaps my learned friend will want to consider and advise on. It wasn't apparent to us yesterday whether, in fact, Mr. Matlala's legal representatives were abandoning the application. And I say so because last night at 20:51, we received an email from his attorneys. And the email says the following, if I may read it into the record, Chair. It says, "Good evening, evidence leader. We respectfully request your urgent written clarification regarding the scope of permissible questions on record. As discussed yesterday, certain questions are excluded due to the pending criminal matter. We attempted to send an email to this effect, but it appears our system may be experiencing technical difficulties. To avoid any procedural uncertainty, kindly confirm in writing which questions may be asked and which are excluded. This confirmation is necessary to ensure proper management of the record and safeguard procedural fairness. We would appreciate your written response." The response to this letter was as follows. Greetings and salutations, and then please note that until the commissioners rule otherwise, there are no questions relevant to the terms of reference which we treat as being impermissible. So that was the correspondence between the two sides yesterday. It was quite confusing to us what the meaning of this was, because what it suggests is a request for the questions, what questions we intend to pose. From that, we thought that maybe the approach being taken is to proceed on the basis of pose the question and then the privilege will be asserted once questions are posed. And so I think that my learned friend may need to just also clarify that.
Ms. Missy, does the letter mean that the application is abandoned, or what does it mean?
Chair, no, the application is not abandoned. The reason for the email is we're trying to anticipate an instance where the ruling perhaps doesn't go in our way. And Chair, based on the ruling that you would make, then Mr. Matlala would then have to apply the right against self-incrimination as and when the questions come. And I believe the thought process was that when it comes to those topics that he cannot claim privilege over, then what are those topics that we can anticipate an engagement over so we can prepare with regards to that? It was not to indicate in any shape or form to my learned friends that we are abandoning the application.
Yes, I must say that it was a very strange request. One can't quite tell whether the request was for all the questions that are going to be asked to be itemized, which would be something that's unheard of and in fact quite bluntly very strange.
Chair, I do take note of the wording as well, the confusion that would have come from it, but my understanding was that I think the attempt was to ask under which topics are you going to proceed on once the Commission has made a ruling with regards to whether we can proceed, or the argument that we make brings the entire process to a halt. Thank you, Chair.
Thank you. May we see council outside, please? The application for a postponement to tomorrow is refused. Mr. Matlala's application must be argued at 12 midday today. Let's adjourn and resume at 12 midday.
Minnesat. Minnesat. I'm better, how are you? Why you sound low? You sound down. What's going on? Yeah, Wednesday is good. Wednesday is good. You will be where? At work? Oh, okay. Oh, yeah, but you let me know. Anyway, I'm good for it. Hmm? Anytime. Whatever works for you. Remember, me, I'm a businessman. I'm at home. I don't run around. You tell me what time, and then I show up. I'm not under. You know, let me not go too far. But yeah, I don't get told where to go, when to go, and how to go. I just do it. So you just let me know, then I'll show up. Yeah, hey man, I was traveling this weekend. They wanted to take my stand back in Free State. And I have started building. They wanted to take it because somebody was claiming it, you know, and so I had to go over the weekend to settle that, and it was like a big issue. I went to emergency. I didn't expect to go, but I had to drive 100 drive. So, but it's sorted. It's sorted now. I'm good now. Yeah.
So when did you left? You left on weekend or you left on Friday?
I went on Friday. No, Saturday morning. I went Saturday morning. Friday, wifey works, so I didn't want her to knock off and then we drive. Yeah, she would be tired. So I just decided because she wanted to come with me. So I just said, okay, let's just make it easy. Let me just go and then let me just wait and prepare for tomorrow. And then we woke up like 3 a.m. because you know how they do things in Emakaya, they do things in the morning. So I had to be at 3 a.m. I was on the road. Yeah. I'm pretty much going almost every weekend. I've been going to Free State due to that, and my nephew not feeling well. So I've been there almost every weekend. I've been driving down and coming back. Yeah. No, now it's sorted, yeah. Now it's sorted. Actually, I'll send you a little bit of a clip. I showed you, Mus.
You didn't show me anything.
I didn't show you. I'll send you a little bit of a clip. The guys are busy. I'm building already. So they wanted to stop the guys from proceeding, saying that because they were claiming it's their place, is their land. So I was like, no, you can't do that. Why when I start building, you coming and telling me nonsense? They should have waited. So they wanted to stop the work from proceeding. Yeah, but I fixed it. So they are continuing this weekend and it keeps better to me. I'm a landlord. It is alarming me. They report the landlord.
All right, it's 29 minutes past 11. We are ready to resume. Please again make sure that your devices are quiet, switch them off, or put them on silent. Thank you.
Ms. Missy, we were advised that we should come back earlier than midday, and that this was at your instance. Yes.
That is correct, Chair. When we were excused or stood down, rather, we received further instructions from Mr. Matlala, having heard the engagement that we had prior to the stand down. And the position that is taken is that he feels that it's unfair that the commission is putting him in a position where he has to proceed where his lead counsel, one, is not here, obviously not of her own doing, but because of an illness that became rather sudden in the manner that it's attacked her. Two, because we've intimated that we've not prepared our heads in written submission, he's of the view that he's not comfortable to proceed because that implies that we're not properly, we're not fully prepared to represent him. And so his instructions are that if the commission is not willing to at least grant us this afternoon to ensure that we have those documents before you and that we have our heads put together properly, in the alternative, he has no option but to instruct us to bring an application interdicting the proceedings of this hearing, pending the review of the decision for us not to get a stand down until tomorrow.
You said something about this afternoon, and now at the tail end you say something about tomorrow. Can you please clarify?
Chair, you'd recall when we began our discussion earlier on, we were requesting that the commission stand us down until tomorrow morning, at which point we had made an undertaking that we would have served you with our replying affidavit and our heads of argument. And so what the instructions are is that our application on an urgent basis would interdict the proceedings of the hearing or him giving testimony pending the reviewing of the ruling that you would have made, which is that we must proceed with arguing this matter, because he's of the view that it's unfair that he's been placed in this position where he has to proceed without Van der Heerver, who is his lead counsel, and without heads of arguments before you, which he believes then implies that we are not properly prepared and we're being strong-armed into proceeding.
Now, this time around, you've not said anything about the afternoon. It's what you said about the afternoon that I want to understand.
Yes, Chair, what I meant is that if we stand out now, it'll imply that we only have this afternoon and evening, I suppose, to ensure that we get the documents before the commission. So that's what the afternoon referred to, that if you do change your ruling into us standing down or postponing until tomorrow, it means that it's just this afternoon that would have to ensure that we have bring the documents or serve them on the commission and the evidence leaders. That's what the afternoon was.
No, you keep repeating that because you don't have your written submissions, you are not ready. Written submissions, yes, they do assist legal representatives, but in the main, written submissions are prepared for the assistance of the decision maker and not so much the arguer. Do you want to address us on that distinction? So those would more have been of use to us, but seeing that the written submissions are not there, we are prepared to forego the assistance we would have received from your written submissions. So as I say, it's more for us than for you.
Chairperson, having engaged with client after we stood down, and obviously with what he had heard during our discussion, his instructions to us is that his observations and his views is that if Ms. Van der Heerver is not here and we have not prepared our arguments for you, it implies that he's not going to be properly represented and he's not comfortable proceeding, which is why he's intimated that should the ruling not be changed to allow us to stand down till tomorrow, it implies that he's of the view, rather, that he's being treated unfairly and he would rather approach a court to have that addressed, Chair. And I do note that you're distinguishing the difference between written submissions and who exactly they're meant to assist, but it's client's instructions that he's of the view if his lead counsel is not here, together with us having not produced the heads before this commission, that he's not properly represented. And unfortunately, I can't comment any further than that because, as you do know, myself and my junior, my apologies, Chair, I forgot to put Ms. Brighton onto record. She's the third junior on the matter. And consequently, he's of the view that he's not willing to proceed, and he would like an opportunity to have this addressed before a court, Chair.
May I ask an issue that we did not raise before? It is this. Why is it that there is no substantive application for a postponement with sufficient clarity? Now it has just been emphasized to us that, as I understand it, the main reason is the fact that lead counsel is not here. Why is it that no substantive application for a postponement on affidavit was brought?
Chair, I think, for one, we did not anticipate that we would find ourselves in a position where we were not able to, firstly, consult with Mr. Matlala yesterday to get the additional information that we needed. Before we left, I did intimate that there is a document that is imported and it speaks to one of the bases upon which we bring this application, but it's obviously of a factual nature. He had to bring it here in the morning, so that's one element. The fact that we didn't anticipate not being able to prepare the replying affidavit. Number two, that then created circumstances that follow when we were not able to proceed and prepare the heads of argument on time to be before, to serve on the evidence leaders and for the commission to have signed off. And so those are the reasons why we were not able to prepare ourselves on time to, or rather, finally, we hadn't anticipated that Ms. Anneline would fall so ill to a point where she's unable to even be here in person. Because perhaps her being here in person as the lead counsel, we would have had a better argument, so as to say, and it maybe have created way for us to proceed to argue on a legal basis. But one thing I can say is that our instructions from client is that if his lead counsel is not here, he's not comfortable and he doesn't feel properly represented.
But the main reason throughout for not proceeding today is the fact that you did not have all the documents you think you require, and that was known for quite a while back, and that had nothing to do with Ms. van den Heever's being here or not being here. So at some point, especially because this morning a postponement is sought on the basis that these documents are not available. Your argument, that was the gravamen of your argument this morning. A reference to Ms. van den Heever not being well was something that was said in passing in your argument. Main reason, the fact that no replying affidavit had been filed, and also the fact that written submissions had not been filed. So the short point I'm making is that that's something that was known for quite a while. At some point, a decision should have been made that, seeing that we don't have these documents, and because we do not have them, we are going to seek a postponement. Let us bring a substantive application for a postponement. That's the point I'm making. The issue about lead counsel not being here arises because I have now directed that I want to hear, that we as a commission want to hear argument on the application, on the points in limine. That's when now the issue of Ms. van den Heever's absence takes center stage, and that has nothing to do with why this morning you argued that there should be a postponement. postponement. I hope you do get that distinction. Can you address me on that distinction in particular with regard
Chair,
to...
I do
just
get that.
let me finish. With regard to why there is no substantive application.
Chair, firstly, I'm just getting notes from a junior. Ms. Van der Heever would have been prepared to argue the matter whether there were papers before us or not. That's the first point. Secondly, we don't anticipate an instance where she would be ill and not be in a position to appear before the commission, which is why we were unable to prepare a written postponement. Because in the morning when we engaged with her and she was being rushed to the hospital to go and have her ailment addressed, we hadn't anticipated that she would not be here in person in time for us to then prepare a written postponement application. What I can assure is that the letter that you sent indicating that you haven't received a postponement application and will proceed absent of that application, we received it at around past 7 in the parking lot of the venue where this commission is being heard. And so, Chair, could we have prepared the postponement application? If we were in this position that we found ourselves in the morning the night before, we would have endeavored to prepare the postponement application. That's with certainty. But because this is something that happened to us in the morning and my instructions were to come before the commission and to ask us to postpone only till tomorrow, that's the reason why you don't have a written postponement application.
Now, I just want to get an idea of how things are to unfold. In the event that I'm not saying we are adopting that stance, but in the event that we adopt the stance that we go ahead with the hearing of Mr. Matlala's application, how will things unfold then? Will you walk out? Will you withdraw as Mr. Matlala's legal representatives? I just want to get an idea of how things will unfold. Going further and saying, if we get to a point, and underline if we get to a point where, having heard Mr. Matlala's application, we do not grant it, and we go ahead with the hearing of his evidence in the normal course, with him, of course, being entitled to raise whatever privilege he may want to raise. So I want you to address me with regard to how things unfold, even looking ahead up to and including that furthest or farthest point.
So, Chair, as you rightly pointed out, it's either one of two options, which is the fact that it would be removed off the brief as his counsel and possibly even his attorneys. The alternative being that you would grant us another ruling, which is perhaps to say within a certain period of time, please ensure that you've served and filed this urgent application with your Part A and your Part B to review my ruling, and at which point would get the opportunity to do so. I must say I wouldn't have...
The application, the interdict, I assume that's a High Court interdict, so yes. Time frames with regard to that would have nothing to do with us. So...
Chair, when I refer to the time frame,
yes.
I'm referring to in terms of us ensuring that we've served you here and not what the High Court or the senior judge sitting would determine would be the ideal time for the urgent to be heard. That's just, again, ideas that I'm throwing out.
Yeah. And may I, sorry to interrupt you. And as you are making your submissions, again, bear in mind, I started with two big ifs. If we reach that point, you should be aware that there will be no interdict in existence at that point. Which would mean that nothing stops the commission from going ahead and hearing Mr. Matlala's testimony.
Chair, as I said, that we hadn't foreseen an instance that the Commission would possibly consider not granting us an opportunity to approach the High Court and address the application that we seek to be heard on an urgent basis. And if that is the case, I don't want to preempt what we would do if you decide not to grant us that opportunity, because for me it's a matter of you're either changing your ruling, allowing us to stand down till tomorrow. The alternative, you say, no, I'm not granting it, at which point the question as to whether are you going to rule, to say, okay, since you've intimated that you want to have my ruling heard on an urgent basis and reviewed, then you have to ensure that I, being then the lead counsel, is prepared to continue and present before the Commission. Then again, as I stated, we hadn't taken instructions, but then I think it would give us, if you could give us an opportunity to stand on further, depending on what your ruling is, to engage with him and consider what the implications would be, because there are different implications should you decide to protest and want to walk away, and who gets to do the walking away, and what those implications as well would be, Chair. I think it's wrong for me to preempt an instance where we decide, because walking away seems to imply that we are protesting, because we'd be walking away in protest. And if you walk away in protest, we've seen in previous instances what the implications are, and the client would have to consider that, and he'd have to give us instructions, Chair. So I can't preempt to answer your question.
Thank you, Ms. Missy. Ms. Hassim?
Chair, I've been listening closely to my learned friend, and it feels like the reasons keep shifting for how we've come about to be in this position. Whether it's because the last submission that Ms. Messi made was that she would make an undertaking to proceed to deliver the argument in the absence of her leader. But if that is the case, then what would be the need then for the postponement? So, and for the urgent interdict? It's not entirely clear to me. It seems to me that, and I have some sympathy for Ms. Messi and Ms. Brighton, that juniors are placed in a difficult position where they have to step into the shoes of their leader. The leader has become unavailable for reasons not in her control. This is what happens in practice, and we are often called upon to step into the shoes of our leader on short notice, and to be prepared to do so. It's not an easy position, but it is one you assume when you take on a brief and you're junior counsel. While I have sympathy for their position, it doesn't absolve them of their obligation to take the place of the leader. They were aware that Ms. van der Heever would not be available today. This could have been brought to our attention much sooner. One of the reasons that was advanced by Ms. Messi for the delay was the inability to consult with the client. That is not a ground, an adequate justification for a delay. That was in response to the chair's question about why didn't you bring a postponement application? Because it isn't the inability to consult on the law doesn't avail Ms. Messi on this. This is a legal argument that is to be made. So, and I've been instructed to put something on record. And I do so without having had the opportunity to make it, to alert my learned friend of this, because it's only came to my attention now while I'm sitting here. And it goes to the point of the complaint by Ms. Messi of the inability to consult in the
Is
commission.
it not Missy? Is it?
Miss Missy. Apologies. Yes. Maybe I've got soccer on my brain. It's only come into my possession. I'm instructed to put it on the record. And it's a message from the area commissioner for DC, Department of Correctional Services, Commissioner Khoza. And what he says, and this is received at 11:36 this morning, and as I said, I'm instructed to put it on record. I'm not going to read the entire thing into the record, just the factual part, not the comments, if I can put it that way. So the relevant part of the message is facts provided are not true. I am not even aware of the challenges advanced to the Commission. I think the challenges that were complained of. And then the next message, they consulted for 3 days and we are prepared to make concessions anytime because we understand the importance of the Commission. I checked with the head of the centre, Mr. Kabengu, on all these challenges. He also denied to have created any disadvantage to them. So that's a message from the Area Commissioner Khoza. And as I said, Chair, I'm just putting that on record. None of that actually changes the legal position that is before you. And the legal position is that a stated intention to launch an urgent application does not itself suspend this Commission's proceedings. Unless and until there is an order from a High Court that interdicts the Commission from proceeding, it can continue, subject, of course, to the Chair's discretion to adjourn. And maybe what I should do on that score is just refer the Chair and the Commissioners to 2 authorities. And the first is the Constitutional Court judgment in City of Tshwane, Metropolitan Municipality versus AfriForum. And it's 2016, volume 6 of the South African Law Reports, page 279. And as I said, Chair, the judgment of the Constitutional Court, and the relevant paragraph is paragraph 74. And then, as it happens, the other judgment I'd like to refer the Commission to is actually the Zuma judgment, but not the one I made reference to this morning, which was Justice Jafta's judgment. It's the other judgment, Justice Khampepe. And the citation of that judgment is Secretary of the Judicial Commission of Inquiry into allegations of state capture, etc., versus Zuma. 2021, volume 5.
Sorry, there was a cough. Volume?
Volume 5.
Thank you.
SA Law Reports, page 327, at paragraphs 94 to 95. So with those, that's also, yes, it's Acting Deputy Chief Justice Khampepe writing for the majority. So with those legal submissions, Chair, we request that...
What do the cases say?
Oh, let me take you to...
You don't need,
the City of Tshwane.
You don't need to quote verbatim. You may just tell us the substance.
Well, it supports a proposition, Chair, that proceedings are not halted pending an intention to bring legal proceedings. It's not halted even if you have brought the legal proceedings. And of course, we know here there hasn't yet been a filing of an urgent application. It is a stated intention to file an urgent application. So that's the proposition. Well, let me just say, Chair, if I could just quote this one short aspect of the City of Tshwane judgment at paragraph 74. It reads as follows: it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted that can in law restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. That's a paragraph to which I referred the Commission to, Chair. So with those submissions, we request that the application from the bar, as it were, for a postponement should be dismissed, and that we should be in a position now to proceed with the questioning of Mr. Matlala as has been planned for some time.
I think the questioning would, if we do get there, the questioning would come after, depending on whether the legal representatives will indeed not be here, but the questioning would have to follow after Mr. Matlala, if he's all by himself, has been afforded an opportunity to move his application in person. So we won't, assuming that we are with you,
yes,
we won't straight away go to the hearing of Mr. And again, assuming,
Chair,
I was once misunderstood by counsel, and we had an unfortunate heated altercation, he and I.
We don't want to have a repeat of that. So, I understand the Chair clearly.
Yes.
Of course, and I don't wish to preempt any deliberation and ruling by the Chair and co-commissioners.
Yes. Yes.
My submission is merely putting forward the position of the evidence.
That actually takes us to a request that was made by Ms. Missy when I asked her how things would unfold if, and Ms. Missy requested a brief stand down for her to take instructions. I would assume you have no objection to that.
I have no objection, Chair.
Yes. Ms. Missy?
Chairperson, I did miss quite a bit of your interaction with Ms. Hashim because I was trying to figure out how we're going to reply to the submission that she's made. Am I going to be given an opportunity to respond to the message that she received? I want to ask that first.
Please do respond, yes.
Firstly, Chair, the only thing that I will say is that those submissions were with regards to from Friday up until Sunday, the filing of our founding affidavit, together with our consultation towards preparing a replying affidavit and the heads of arguments. It does not speak to any interaction prior to that. Secondly, if I'm being challenged on the submissions that I've made to this commission with regards to that on a factual basis, I do believe the timestamps of when I went in and went out, because I was present on Friday and I was also present on Sunday, can be looked at. That will show you how long I waited, where I waited, what happened, and ultimately, for example, at what time I got the opportunity together with my learned friend, Ms. Brighton, to eventually sit down outside of the Correctional Service Center and rather email the signed affidavit. So with that being said, Chair, I can only say that. If I'm being questioned as to whether I'm misleading the Commission or I'm casting a particular view about the Correctional Service Center, I'm not. I was simply saying that the Commission is not aware, and any layperson out there is not aware that they have rules and they keep to their rules. And that has affected how we operated on Friday, Saturday, and Sunday. But if I'm being questioned, the timestamps, and I'm sure they have recordings, the times we signed in, as well as cameras to indicate whether I'm misleading the Commission or not. That's as far as I can take it.
Thank you. There is no way that based on what we are told from the bar, from both sides, there's no way, seeing how contradictory the two versions are, that we can take a decision on that. And in fact, I think for present purposes, it's not even necessary for us to take a decision or to go there at all. Do you wish to reply to the rest of...
Chair, sorry, that threw me off a bit. Oftentimes when you are on the legal representative side and you're being called to question about whether you're lying or not, it does throw you off because it speaks to your integrity as a legal representative. I wanted to, because I believe in our earlier engagement, I wanted to distinguish between the position that's been taken by our client, Mr. Matlala, by the client, Mr. Matlala, as well as the arguments that I made earlier on, Chair. So the arguments that I made earlier on are in relation to us, whether we can proceed and why we're saying we should stand down till tomorrow. The second element of it, having come back and taken instructions from clients, those are his instructions about how he feels in terms of us having to proceed. Should you insist that we proceed today and not wait till tomorrow? So there needs to be a distinction between the two. We're not shifting the goalposts from this is what we were saying earlier on in the morning, and now we're changing and we're saying this here. What I spoke to mainly, now that we've come back after the stand down, is with regards to the instructions and his observation, how he feels about it. The earlier part still stands as it is, where you are asking us and we have to address you as to whether we proceed or we don't proceed, and you made the ruling that you made, which is that we proceed at 12:30. So I just needed us to make the distinction.
You do still need this stand down with regard to how things will unfold in the event that the decision is we are going ahead.
Chair, we still do need to stand down, but
we
we had a discussion when we were hoping that it doesn't come off as if we're being hostile, as because it somewhat has underlying for us that, oh, so now you need to go and preempt. Are you going to walk away from us? It gave that impression. But if
no, it's just wanting to know how things are going to unfold. There's nothing judgmental about it, and I have not observed any hostility. I just want to know how, if we do get there, again, underline if we do get there, what's going to happen?
Chair, I would appreciate the stand down. Chair, I would appreciate the stand down to just quickly take instruction from client, and then I'll come back with a response if you do decide to rule otherwise.
Yes, thank you.
Noted, Chair.
Thank you, Ms. Hasim.
Chair, it's very important for me to make one remark.
Yes.
And it's in relation to the message that was received by the area commissioner.
Yes.
My instructions were simply to put it on record.
No.
I take no position on whether my learned friend, Ms. Missy, is misleading this commission or anything like that. That's not my intention, and I do not wish to be misunderstood at all to be suggesting that. It's simply an objective message that was sent through that I put on record, and I think perhaps what it is from the commissioner's side to say we are not being obstructive.
Yes.
But the fact that it is difficult to consult with a client who is incarcerated, if any of us who have gone through that understand that it's a difficult process. And so I just wanted to make that clear.
An important takeaway actually from that text is this. As Ms. Messi was arguing this morning, I actually did think of the possibility of the commission engaging with the prison authorities to ensure that the difficulties Ms. is telling us about do not recur. Now, a good take-home or take-away from this text is that such an engagement will actually, there will be no resistance to the request that I already had in mind.
Quite so. Thank you, Chair.
I will not indicate it. Yes.
Chair, my learned friend just highlighted something. I did speak about how we often use our cell phones for internet. We use our cell phones to get Wi-Fi through them to connect to our phones. If that request could specifically include that we have our cell phones, because that would really make things easier for us should we have to engage with him later on, to allow counsel at least one cell phone to come in with us. We don't all have to have our cell phones with just one cell phone, so that we don't have this issue of internet not being present, etc. Because what would happen is that, for instance, if we need to have a document and he's happy with it and we have to file it, it's just a matter of him signing it, we can scan using our phones. So, and then we would be able to send it immediately and wouldn't have all these issues of we don't have the internet, we need to leave, we need to come back, etc. So a request that you specifically include there that we are allowed to carry in one cell phone for purposes of having access to the internet.
That will be considered.
Thank you, Chair.
I'm saying considered. Let's adjourn. I will not indicate a time.
You'll tell me when you want to.
Yes, Ms. Missy.
Chairperson, thank you for giving us the time to deliberate over the hypothetical questions. The first one being that in a perfect world, we would anticipate that you would say, yes, I'm giving you the additional hours and I want those documents, and whether you're prepared or not, tomorrow proceeding. That's when we win and we get our kitty and we walk away. In the instance you rule that no, we are proceeding, our options would be to go off record as his counsel, and he would be without representation, it implies. Given the fact that...
Counsel only or counsel and attorneys?
Counsel and attorneys.
So, or you will no longer be representing him?
That's correct.
Yes, yes.
So that would be the hypothetical scenario that we'd find ourselves in if you decide that you're not willing to give us the additional time to come through prepare tomorrow. Again, I do want to stress the undertaking that we're making, which is that should you decide to rule to give us the additional time, whether Ms. van der Heerwe is here or not, we will be proceeding to argue. Whether you have received the papers or not from us, we will proceed to argue orally with or without the papers.
You say when?
Tomorrow morning.
Tomorrow.
Should you decide to rule in our favor that we should go home and come back tomorrow prepared. What I'm intimating or suggesting is that the scenario you would have is that whether we file the documents or not, we will be proceeding to argue. Thanks, Chairman.
Thank you, thank you.
Ms. Missy, when you say off the record, you mean you withdraw as his legal team?
That's correct.
Would that go for Ms. van der Heerwe as well?
Those are the instructions that I received as well with regards to, so it would be the entire team.
Okay.
Thank you, Commissioner.
Oh, and there was... When she placed you on record, Ms. van der Heerwe, last time, she said there was another firm of attorneys as well. Are they present here, and do they also withdraw? Because it's not just the people that are sitting behind you, as we understood here.
Yes, I actually just realized right now that Mr. Maluleke is and his firm still is part of this team, so they would also withdraw from there. Can it be the entire team, all attorneys and counsel?
And that's your instruction from Mr. Matlala?
Those are our instructions.
From Mr. Matlala?
That's correct, hypothetically speaking. Okay. Yes.
Mr. Maluleke is not with you. Has there been a discussion with him? Because it's important that we don't end up with a situation where, if this eventuality that you're contemplating happens, that we don't end up with a situation where he comes to the commission and said, I never put myself off record. The team that was here on Monday were not speaking for me, and I hadn't spoken to Mr. Matlala. So I think it's very important that we are clear about that.
I'm glad that you raised it, because that could potentially happen, hypothetically speaking. And with that being said, because these are instructions and engagements that we had with Mr. Matlala, and Mr. Maluleke is not here in person, I suppose then, in fairness to him, he has not commented on that element. These are just instructions that the entire team would be off record. But I suppose in that instance would have to engage with him and consider his stance should we find ourselves in that position. I suppose there won't be a need for us to stand on further until we've had a ruling. It just gives an idea of where we potentially would be. And if that is the case, we'll engage him and inform the Commission of his position.
Yes, I think... Ms. Missy, this eventuality that you are contemplating, I think it's very important that we all are clear what it is you're saying. You are using language of off the record. My experience is counsel say, I'm withdrawing. I'm no longer on brief. I'm not counsel on brief in this matter, and I'm withdrawing because for their personal reasons or because that's the instruction from the client. So just so that there's no confusion, can we clearly understand you? You are saying in the event you do not get, I'm going to say your way, because that's what it is. If you don't get your way, or Mr. Matlala's way, you are saying to us your instruction from Mr. Matlala is that the entire legal team, and I'm happy to leave aside Mr. Maluleke for now, you're saying your instruction is that the entire legal team, counsel and attorneys, including Mrs. van den Heever, you withdraw as counsel.
That's correct, Commissioner.
Okay.
That's
Thank you.
correct.
Who is the senior attorney? This is something that that's so crucial that I think we should hear from the attorneys directly. Who is the senior of the attorneys? And
That would be Mr. Baloyi.
Please come to the microphone and. No. Please state your name for the record.
Thank you, Commissioner.
And your firm.
Yes, it's Mr. Baloyi with initial N from Baloyi Attorneys in Pretoria. Yes.
I asked if you also confirm that if our decision is that we proceed with Mr. Matlala's application, is your decision that you, as Mr. Matlala's attorneys of record, are withdrawing from representing him? If our decision is that we are proceeding, is that, do you confirm what counsel said?
Yes, I do confirm the submission made by the council.
You will be withdrawing, yeah. Perhaps, thank you very much, Mr. Baloyi. I think we've reached the stage where we should. Ms. Asim, I'm not sure that you would want to say something, but perhaps because this is not really your decision, if haven't we reached a stage where we should just indicate what we think?
Chair, there was
or what I think, because I think our regulations and rules really say that process-related decisions are mine, and indeed all rulings that have gone out go out. Even if signed by the Commission Secretary, they go out under my name. But of course, for practical reasons, I'm always assisted by my co-commissioners. But ultimately it's my decision.
Chair, there's
yes.
nothing that I can usefully say in response to the last
Yes,
submissions that have
yes.
been made about withdrawing, etc. So it's in the chair's hands.
Yes, thank you. I will address Mr. Matlala directly on this. Mr. Matlala, I just want to get an idea whether you two confirm that after your counsel or legal representatives were afforded an opportunity to consult with you, what was agreed upon is that if my direction is that we go ahead with your application, they will then withdraw as your legal representatives.
Thank you, Chair.
Can you please switch on both microphones? Yes, thank you.
Thank you, Chair. Chair, we had 3 scenarios, so I'm actually in the dark now because while I was having lunch, I didn't have enough time to conclude what we've been discussing, so we just came right straight here. So I do not know whether my legal counsel, what they are saying now is what comes from Mrs. van der Heever as instruction or not. So I'm actually in the dark. I don't know what to say.
So basically, you are not really party to what has been announced.
No, we've discussed the options, yes, but I haven't had the time to make up my own mind. So,
all right, maybe the best is for me to announce the decision. Having considered everything that has been presented to the Commission, my decision is to go ahead to hear Mr. Matlala's application. That's the decision. Ms. Missy?
Chairperson, given the fact that Mr. Matlala, being our client, has now confirmed that he hadn't settled his mind because we labored under the impression that this is where we're standing and these are our instructions, given the fact that he's of the view that he feels confused now, he's no longer with us, will you please grant us an opportunity to then finalize and get the instructions so we don't have this situation again?
Ms. Missy, the withdrawal of counsel and legal representations is not, strictly speaking, a matter of instruction from client. It's ultimately a decision taken by the legal representatives. They choose on their own for whatever reasons that we have now reached a point where we can no longer represent our client. Therefore, we are withdrawing as legal representatives. I don't know whether you are now suggesting that it was not a properly considered decision. I'm not pushing you to withdraw if you've suddenly become ambivalent about it.
Chair, remember we were operating under hypothetical instances. Now that we know definitively what your position is, I do believe that we ought to be given an opportunity to finalize if really we're sticking to that position of walking away or not. As you've noted, that perhaps we might feel a bit ambivalent and would feel we want to continue. This was what we're simply requesting, Chair.
Ms. Missy, what's happening now is deeply problematic. I asked you directly, is it your instructions from Mr. Matlala? You said yes. That's deeply problematic. Whatever stand down you get to go and consult with him, I would like you to end on that note from me. It's deeply problematic what just happened now, and I hope you find a way to address it. Because what it suggests and represents is what you said in response to my direct questions, is that is not the true position, given what Mr. Matlala is saying now. If you come back to say it was a misunderstanding in whatever form, that I'm prepared to grant you that, but it is deeply problematic. that you have put firmly, those are your instructions from your client. And now you say, well, maybe we need to go and discuss. I want you to understand my concern about it.
If I may, Commissioner, I do understand your concern about it, and that's the reason why I specifically have asked if the chairperson, the commissioners, could let us stand down, because I was laboring under the fact that those are our instructions. Now that he has intimated that he does not feel that he's on the same page with us and he does not understand, that implies that there's been a misunderstanding, and that's the reason why I would like for us to address this, so that when we come back before the commission, then we don't have this issue happening again. And to add over that, if you recall, this is a hypothetical situation that we're talking about. Now that you've made your ruling, that implies that we need to come back to the chairperson with a final decision of what are we going to do. Chairperson, I don't know if...
And as I said in my ruling, at this point, this is only about hearing Mr. Matlala's application. We have not reached the stage of the continuation of his testimony. That's where we are, just for clarity.
Thank you, Chair and Commissioners.
And Mr. Matlala, you are fortunate to have had lunch already. We are yet to have ours. No, I'm mentioning that because you said when you were having lunch earlier during the break that we had. Because it's 3 minutes before the lunch adjournment, maybe let's just take the lunch adjournment and resume it at 2 p.m. And let's have hear from you, Ms. Missy, at that point.
Thank you, Chair.
And I hope everything will have been clarified, and that one way or the other will then hear Mr. Matlala's application, whether you continue to represent him or whether he is moving it in person. Let's adjourn and resume at 2 p.m.
What's up, everybody? I'm back, and this video is a follow-up to the previous video that I made. As you can see that I set up my cameras. I have two cameras. I have one facing me right here, and the other camera is over there on the other side. And I'm using, that is my Lumix GH5, and then this is my Canon 5D Mark III. And of course, that I set up both cameras to shoot on high definition, just the 1080p. This can shoot only up to 1080p, and that one can shoot up to 4K. Usually I would prefer to have that camera shooting. Let me turn it around. I'm just gonna have to show you where the other camera is situated. Just give me a minute. Over here, that's the other camera. You can see that it's looking quite small. It's looking tiny. That is the other camera. So I'm using both cameras. What's important about using two cameras to shoot is that you get both angles. You can have this one over here. This is like a close-up, and then that is the wide shot. It's a wide shot with a long lens, of course, and this is a close-up with a, I think it's 24 to 70 millimeter f2.8, and that one is a standard prime lens. It's 50 millimeter on a macro four third. When I shot my web series Identical, I had a challenge of using two cameras that could not even come closer to having the same type of footage. The other footage was completely out. I'll show you a few scenes of when we discuss that. I will open that on my PC and show you both videos so that you can actually decide for yourself and see for yourself that it wasn't matching. Now today, before I start shooting this, actually today again, I'm still using natural light. I have two lights. I think you saw me moving them over to the other side of the kitchen. I have two lights. I didn't put on any lights again today, and the reason for that again is just to see how will the video look without the light. Now let's talk about this. One of my favorite short films that I've ever watched on YouTube, besides the horror films that are done by David F. Sandberg, is Tom Clancy's Ghost Recon, that was edited by Film Riot. That is one of my favorites, and I'm creating a similar project myself for me, and that particular project is going to be a very serious one, and I'll be casting, I think, sometime in the future. Not today, not soon, because I want to finish first the script, finishing the script, and then I will cast after that. And it's gonna be based on the similar concept, but local, of course. And so let's take a few minutes and see the beginning of, actually few clips. I think I have to give you a few favorite scenes of mine from Ghost Recon, because I think it's about 10 something minutes and I don't have that much time to show you. Let me see how long is the film. I just want you to see the film is quite a long short film. It's not as short. Yeah, so I want us to see. It's Ghost Recon. Let me just quickly swap again to different account over here so that I don't struggle with the ads. Where is that? This one over here. Not that. Which one did I go to? I have to change again. Yeah, so it's one of my favorite films. I went to the wrong one. Let me go to. It won't show. Oh, it will show. Switch account. I want this one. And let's see if I can see Ghost Recon. Just the length of the film. It's amazing movie. Wide lens. Ghost Recon Wide Lens, guys. It's one of the best short films, and I won the movie. The trailer is 5. I mean, how they made a trailer 5 minutes? You can't have a trailer that's like 5 minutes. A feature film trailer is like how long? It's 1 minute, less than 2 minutes. They made that one 5 minutes just for the trailer. That's how good that movie is. And by the way, Tip, Tip, I don't know if it's Tip or TIP. He's on that short film. Movie. I don't want that trailer. Movie. Let's see. It's done by Ubisoft, directed by it's 30 minutes. The movie is 30 minutes, so I'm gonna take just a few clips on it just to show you how amazing that film is. Of course, it's done with high-end equipment. It was done by professionals who've been doing films for a long time, and was edited by Film Riot, Ryan Conley. So I want us to think about that, because I'm going to be finishing my script for my similar concept film that I'm writing, and I can't wait. So let's watch Ghost Recon Wide Lens. Let's see. Yeah, Wide Lens. It's based on the concept of Tom Clancy. You know, Tom Clancy is the guy from who wrote movies like what's that guy? The one that are on Prime. Tom Clancy's movies on Prime movies, Amazon Prime. Let's see. Tom Clancy. I just want to. It's Jack Ryan movies. But my favorite on Jack Ryan films, except for the Jack Ryan a series, it's Jack Ryan Shadow Recruit, where the starring there is this guy. What's his name? The starring on Jack Ryan Shadow Recruit is what's this dude? This name? Chris Pine. Yeah, that's my favorite. I can watch that movie over and over, and I have to have that movie as soon as now. Cheers, guys. See you on the next video. So watch this clip and then go to see the Ghost Recon Wide Lens film on YouTube, Ubisoft. I'll put the link on the description for this video. Cheers, guys. See you. good, how are you?
I'm very well, sir. Thanks very much for asking. My apology for the unexpected call there. You are speaking to Dolly. I'm calling from Madlanga on behalf of country.
Okay. No, I'm good, thanks. I just renewed my tracker last week. So I just got a new one, so I don't need to do another quotation for now, thanks. Yeah, but I won't be able to take it for now. Thank you, bye-bye.
We're about to resume. It is 13:59. Please again make sure that your devices, your cell phones are off or on silent. Please stand. Thank you.
Ms. Missy.
Chairperson, we have consulted with the client, and with regards to the misunderstanding, he would like to address the commission about the misunderstanding relating to the issue of the hypothetical scenario and the instructions that he has given us. May he be granted the opportunity to do so?
Thank you. Yes, Ms. Matlala.
Yes, thank you, Chair. Chair, I was of the view that the question that you raised to me was a final question that I'm terminating my mandate to my legal counsel, and hence before that I explained that we explored 3 scenarios.
Oh, please switch on your second mic, please.
I'm sorry about that.
No problem.
Yes, I'm saying it's a huge understanding because my counsel was raising the scenario as hypothetical, and then it was not a final thing. So I was of the view that your question was, am I terminating my mandate to my legal counsel? And then hence I said I was in the dark. But obviously it was a very huge misunderstanding, so I wanted to clarify that.
Now that this is no longer hypothetical and I've made a ruling, what's the position now? Do I hear you, Ms. Missy, or do I hear Mr. Matlala?
Chair, you can hear me on that. Chairperson, we've deliberated with Mr. Matlala, and he has requested that we remain on brief as his counsel and other attorneys of record. The position that we found ourselves in with the legal advice, given the circumstances that we face, which is one that Ms. van der Heever, as you correctly pointed out, has been preparing on these points for as long as she's appeared here. And we've come in at a later stage and are not properly prepared to argue these points, and he's not comfortable with it either. His suggestion was that we could proceed with the hearing as is, and then he reserves his right to claim privilege as and when the questions are posed to him, and if necessary would then advance arguments before the commission.
And what should we consider the status of the application to be? I'm happy for us to go along those lines. But what is the status as a matter of law? What is the status of the application then? I'm not pushing you to.
It sounds like
yes, it's actually a practical. Maybe let's just go ahead then with the evidence. That's what Ms. Missy says.
Thank you, Chair.
And as the answering affidavit of the evidence leaders and written submissions say, it's still open to Mr. Matlala to raise privilege. Nothing stops him from doing so. And I also understood you to be saying exactly that, Ms. Missy.
Chairperson, those are our instructions
Yes.
from him, that he still reserves his
Yes,
as
yes.
and when you ask the questions that he raises the privilege against self-incrimination.
Yes.
I do have one point that we received instructions about earlier this morning after considering the last affidavit that we received. I don't know if we could be granted an opportunity to address it before we proceed, because we do deem it pertinent that it's addressed, and you can give us
What's that issue?
the issue regarding the affidavit that was deposed to by Mr. Dlamini, the senior investigator.
Let's just proceed with the testimony, unless Ms. Sillo is proposing to start with that. Let's just proceed and avoid that affidavit because a lot of time has been wasted already.
It has, Chair, and I definitely am not starting with that affidavit.
Yes, yes.
And I think I'm looking at the time. Chances are that we are unlikely to get to the affidavit today, just to put it out there. But I see Ms. Hassim wants to say something.
Oh, And yes, Mr. And I forgot to say, and you are excused. But let me hear you.
I'm afraid I'm not excused because I'm responsible for this witness as well.
Yes.
It really is to just close the loop,
Yes.
Chair, on the application that was brought.
Yes.
That to say that the commissioners have the written submissions of the evidence leaders, and just for the sake of the record and for everyone to understand what the meaning of it is, we obviously do not take issue with Mr. Matlala's right to assert his Section 3(4) privilege against self-incrimination. What the problem was with the way in which they brought the application was asking for a blanket immunity from whole swathes of parts of the evidence, which would have undermined this commission significantly. So on that understanding, Mr. Matlala is free to assert his right himself when and as he wishes, and the chair will make a ruling on it at the right point. Thank you.
Thank you. If you are able to, Ms. Sillo, maybe just try to avoid the issue of that affidavit for the rest of the day, but only if it's practical for you to.
No,
please, yeah.
I confirm it is, Chair.
Yes,
I have a few issues to engage Mr. Matlala on without having to touch on that affidavit.
Thank you.
I just need to confirm, and good afternoon, Mr. Matlala. Mr. Matlala should have next to him at least 3 boxes of files. Is that the case?
Yes, I do.
You do. Chair, now, I haven't had a 2-minute stand down for my projector to come sit by me, but we shall make the best of a bad situation.
Let them just walk across or not?
Okay, if she may, I would appreciate that.
The laptop is connected. I was trying to avoid another adjournment. I guess we are forced to. We'll hear from you. Let's adjourn.
2 minutes. Thank you, Chair.
Which files must we take out?
1, 2. All right, we're ready to resume. Seemingly not. Just 1 second. Clearly not. All right, it looks like we've got a green light. Let's proceed. Cell phones off, please. Thank you.
Yes, Mr.
Thank you, Chair. Chair, just a reminder for the record, when we parted on the 21st, Mr. Matlala had asserted his right to supplement, and in fact he had made certain undertakings to supplement his original statement. Mr. Matlala, do you have before you file 1, which should read Regulation 10.6 Statement and Annexure? That's the original file with your statement.
Can I please check?
You will recall that in dealing with that statement, we first had regard to the Regulation 10.6 notice that had been issued, to which was annexed a schedule with a list of names and names of individuals. And you had been requested in the 10.6 to explain any relationship you have with any one of them. You recall that?
Yes, I do.
And in the course of considering the contents of your statement, it became apparent that you hadn't addressed some of the persons listed in Schedule A. And you undertook to do so in your supplementary statement. Do you recall?
Yes, I recall.
And that's the basis on which we parted, Chair, on the 21st, that he will supplement and provide detail on such individuals that he had not addressed in Schedule A. At the same time, that's when a decision was taken that they will institute this application to raise preliminary points, which they did. The challenge we have is, much as we expected Mr. Matlala and his team to file 2 separate documents, one being a supplement to his original statement and the other being the application raising the in limine points, they combined the 2 to create one document. We have attempted to look at that affidavit that they have filed in support of the application to get a sense of what would constitute supplementation for the purposes that I have highlighted. And with your leave then, Chair, I would invite perhaps Mr. Matlala to address the relationships of the various individuals as reflected in this affidavit, but only those aspects of this affidavit, and not read the entire affidavit as if it is a supplementary statement, if that is acceptable. Mr. Matlala, that was communicated to you, I think, by your legal team, that that's how we propose to deal with this matter of supplementation.
Okay, it's fine.
Okay. Now, if you have your list, then Schedule 8 to the Regulation 10.6 at page 7, you recall we marked those that you had addressed. There is a list of them that you did not address, items 13, I think, to 25, on the basis that, to 24, I think, on the basis that they are your co-accused in the Medicare matter.
Yes, that's correct.
So then, if you look at your affidavit in support of this application brought on your behalf, that would be in the second file, and that file would be marked application for immunity, supplementary affidavit. Do you have it close by?
Yes, I have it.
When I cast my eye on that, I see that up until page 10, you deal with, page 12, you deal generally with the basis on which you move this application and you are setting off your constitutional rights. You address for the first time at page 13 the issue of EMPD. And you recall that if you look at the Schedule A at page 7, at item 28, you were requested to speak about Commissioner Julius Mkwanazi. Yes, Commissioner Julius Mkwanazi. And you had been requested to provide an explanation of your interactions and business engagements with such entities as the EMPD, that is at item 2.1.6 of the 10.6 regulation notice. You recall that?
Yes, I do.
Now you respond to that then at page 13, starting at your paragraph 60, supplementing your original statement, paragraphs 62 to 65.
I have responded to this question in my previous affidavit. I have been advised to also place on record that I am a suspect in case involving the EMPD, and I therefore do not wish to answer any question regarding my interaction with the EMPD. I attach here to a copy of a statement deposed to by Intervision Cordelia Kabeng, from which it is evident that I am a suspect in a case under investigation by members of the IPID, under case number 262/2023, relating to the unlawful fitting and usage of blue lights. A copy of the statement is annexed here to marked VMSA1. Other companies, I have not done any business with the aforesaid entities through any of my other companies.
Thank you. I'll then propose we jump to page 14 from paragraph 71. Under 71, you say, in respect of the individuals I list herein under, I wish to amplify my original affidavit, and then you detail the individuals. Could you read the headings and the relevant subparagraphs to the name into the record, starting with subparagraph 71.1?
I have answered this question when I gave evidence.
Read the name as well.
Oh, sorry.
Yes,
Okay.
yes.
Minister Senzo Mchunu, I have answered this question when I gave evidence. Former Minister Becky Cele, I have partly answered this question when I gave evidence. I do, however, wish to state that I am a suspect in a matter under investigation which relates to my interaction with him, as was made clear to me during my questioning by IDEC and as was later recorded in the statement I made in terms of the provisions of Section 204 of the CPA. Former General Komoto Pahlani, I have answered this question when I gave evidence. Lieutenant General Nhlanhla Mkhwanazi, I have partly answered this question when I gave evidence. I do, however, wish to state that I am an accused in a matter on trial pending before the Johannesburg High Court under case number SS98/2025. I have also noted that Lieutenant General Nhlanhla Mkhwanazi has stated under oath that he recorded the conversation we had on the day I met him. I now invite him to disclose this recording to Commission so everyone can hear firsthand what happened on that day. I respectfully point out that I do not understand why such an important piece of evidence have not yet been subpoenaed or voluntarily handed over to the Commission. Lieutenant General Mole Fefani, I have dealt with this issue in my previous affidavit. Major General Feroz Khan, I have answered this question when I gave evidence.
Thank you. I would then, on my reading, it would appear that we should take it from paragraph 72, because you are responding directly to the paragraphs in the subpoena. You start with paragraph 2.3.2, and just to quickly remind you, that had required you to speak of your involvement in the incident of delivery of impalas to General Sibiya and any other forms of gratification given to General Sibiya. You deal with that at paragraph 72? 72 and up to 74. Thank you.
I'm a suspect in a matter under investigation which relates to my interaction with him, as was made clear to me during my questioning by IDEC and as was later recorded in the statement I made in terms of the provisions of Section 204 of the CPA. One of the matters related inter alia directly to the issue of the imbalance. Another of the matters relates to payments of gratification.
And then that would take us then to your response to paragraph 2.3.3, and this concerned the circumstances in which Sergeant Ngosi came in possession of your Luxor Africa bank card. You deal with that at paragraph 75.
Luxor is a co-accused of mine in the Medicare matter, and therefore I cannot comment and or provide any evidence relating to that matter. I therefore exercise my constitutional right not to answer any questions regarding the said matter, as same will violate my constitutional fair trial rights under Section 35, including my right to silence.
And proceeding then to your paragraph 76 to 78 in response to paragraph 2.3.4 of the Regulation 10.6 notice, which required you to speak of your involvement in the loan or funding agreement entered into with Mr. Sulem Karim on or about June 2024.
I have given instructions to my legal team to endeavor to obtain relevant paperwork on the matter relating Mr. Karim. At the time of signing this affidavit, they had not yet obtained anything, and I thus observe my right to supplement this affidavit regarding this aspect. Notwithstanding a thorough search of the records in my possession, I was unable to obtain any documents relevant to the question under reply.
Thank you for that. That will then bring us to a response to paragraph 2.3.5 of the Regulation 10.6 notice, which had asked you to comment on your appearance at the ad hoc committee and whether you were ever induced, threatened, or influenced to give false evidence, including the details of who induced or threatened you to give false testimony, when, how, and for what purpose. You deal with that from paragraph 79 to 83 at page 17, if you could read those into the record.
May I just quickly raise something, Mr. Matlala? It relates to paragraph 77, saying that you thus observe your right to supplement this affidavit regarding the aspect you are dealing with there. I'm not altogether sure that it's a matter of right for you to supplement. Perhaps this is a legal question which maybe Ms. Missy should respond to. And I've seen this point being made a good few times in this affidavit. It was already an indulgence for you to supplement, and something that I granted or allowed without any reservations. I just want to avoid a situation where it's suggested that it's something that should happen as of right. Ms. Missy?
Chairperson, this directly relates to him claiming the rights of privilege in terms of Section 3.4. We would be required to show or give factual basis why it is that he wants to claim it. But in order for him to do so, he needed us to find that piece of information that he wanted us to research and provide to him so that we can confirm, in order to allow him, or rather enable him, to claim his right before this commission when it relates to issues that have to do with Mr. Karim.
I read this differently, Ms. Missy. I read this to be saying Mr. Matlala is asserting a right to supplement the content of his affidavit with regard to the issue being raised about Mr. Karim. I did not understand that to relate to the privilege that Mr. Matlala is claiming, or am I misreading this?
Chairperson, you are correct insofar as that he's asserting a right to supplement the affidavit in order for him to be able to claim the right of privilege, because as it stands, he has informed us with regards to why he would want to claim the right to privilege. But in order for us to do so, we'd have to lay facts to it, as previously argued rather on last week Monday. But we were not able yet to obtain the information that he needs. And so it put us in a position where we had to answer how would we then later deal with it if and when we do obtain that information that would put the commission into light that indeed he's either a suspect or an accused, and therefore he would be in a position to claim the right to privilege.
Can you please take me through paragraphs 76 to 78 and show me where it's intimated that with regard to Mr. Karim, Mr. Matlala wants to raise the issue of privilege? Again, I repeat, I'm probably misreading or misunderstanding.
Chairperson, I agree with you that it doesn't categorically say so. I'm simply explaining why it is that he was asserting that right with regards to claim.
I guess my point is, where do you get that? Where do you get what you are saying? Because I do not see it in paragraphs 76 to 78.
Chairperson, in that instance, the only submission that I can make is that should we have come across, or should we obtain that piece of information, then the supplementary affidavit, he would then refer to it to say the reason why I had asserted such a right was because of this facts that are now being averred in this affidavit and or statement. Chairperson.
Let's leave it there. I do not understand you. Let's leave it there. Mr. Matlala, do you want Ms. Sildo to repeat a question, or are you in a position to go ahead and respond?
No, it's okay. I can go ahead.
Thank you.
Chair, before we do, I think perhaps in fairness to Mr. Matlala, we should consider the contents of his paragraph 17 in the original statement regarding this loan and the loan agreement. And in that paragraph, he states, I'm of the view that I may incriminate myself by answering questions related to this loan agreement, as I believe it forms part of the Medicare criminal matter which is pending before court. It's just that my reading of paragraph 76 and 78 don't tie back to the answer given in there, and instead they speak mainly of the right to supplement.
Yes,
which doesn't answer the chair's question. But
which
I
is what
thought to bring
caused me to raise the question.
To bring to your attention.
But thank you for
Thank you
for that, Mr. Yes, Mr. Matlala.
So then you have read your paragraph 76 to 78 of your affidavit into the record to supplement your original response to paragraph 2.3.4. That then would take us to 2.3.5. And at the time, 2.3.5 called on you to speak to your appearance at the ad hoc committee and inquired whether or not you had ever been induced, threatened, or influenced to give false evidence. And if so, that you provide the details of who induced or threatened you to give false testimony, when, how, and for what purpose. You respond to that specific question in the affidavit at page 16, starting from paragraph 79 to 83.
I am not responding to this question for the following reasons. When I attended the ad hoc committee, I was not yet arrested and charged as an accused on the Medicare matter. I was also unaware of the fact that I was a suspect on some of the issues I was questioned on. It has now emerged that I am a suspect in a matter later recorded in the statement I made in terms of the provisions of the Section 204 of the CPA. I therefore state categorically that I'm not prepared to answer any question I have previously answered on which I have now been charged or in which I am a suspect. Answering such questions now will violate my rights to a fair trial and my right to silence and my right not to incriminate myself. I have also been made aware of the fact that stand to be accused of having made previous inconsistent statements, and more importantly, that I can be charged with perjury if I deal with any of the ad hoc issues.
If I can just, by way of seeking clarity, you do note that if one has regard to the question posed to you at paragraph 2.3.5, you haven't answered the key question there, whether or not you were induced, threatened, or influenced by anyone. Should I understand you correctly that your position is you cannot answer definitively to that question because any response you give thereto, you run the risk of incriminating yourself?
Yes, Commissioner, you're right.
Including an answer that says, no, I was not induced.
My worry is if I say no or yes, the next question, let's hypothetically saying I'm saying yes. The next question will be by who and then why. And part of those who and why might somehow end up incriminating myself.
Okay. We will come back to the issue in the fullness of time. Just wanted to get some clarity. If you recall, then moving on at paragraph 2.3.6, you were asked to comment on the recording of your interrogation on December 2024 and May 2025 by witness C or any other police officers who interrogated you after the arrest. You deal with that at page 17 at paragraphs 84 to 86.
I have been provided with copies of any of the recordings of my interrogations, whether the same way in December 2024, May 2025, or thereafter. I have dealt with this issue above. Legal argument will be made on this issue as to why I should not answer any questions relating to these recordings.
When you say this issue has been dealt with above, you mean in the body of this affidavit, where it is suggested, as the affidavit does, from paragraph 41, that you intend to launch a challenge to the seizure of your cell phones, as well as your challenge to... Now, I just see the cell phones. Where you say above, where do you deal with the issue of the recordings? Oh, you do please refer to page 9, paragraph 35. You stated, paragraph 35, I have learned as a result of information obtained from the Commission that the subs have obtained a number of statements from me in violation of my constitutional rights contained in Section 35. And then you reference certain recordings. Is that what you mean?
Yes.
So, if then I reread your paragraphs 84 to 85.
Maybe, Mr. Law.
Yes.
The paragraph 35 is about statements, but if you go back, paragraph 32 and 33, that's where he speaks of recordings. So there's he distinguishes, Mr. Matlala distinguishes recordings and statements.
Yes, at 32 he says, I only learned later that the interrogation of me and my responses were electronically recorded at the time.
Yes.
Do you see where Commissioner Baloyi is directing you to?
Paragraph 32.
Paragraph 32 of the
Yes,
same document
yes,
we are looking
yes.
at page 8. And you say this recording and a transcript thereof was made available to my legal team after it was requested from the Commission. So I'm saying, regard being heard to what you state at paragraphs 32 to 36, that's the basis on which you say you've dealt with the issue above at paragraph 85, and that legal argument will be made on the issue as to why I should not answer any questions relating to these recordings. You state that at your paragraph 86.
Yes.
So your response to paragraph 2.3.6, then, that to clarify, is dependent on the determination by the commissioners and the chair as regards your claim, your suggestion that your rights were violated as set out in paragraphs 32 to 38. You will not answer until the question of the suggested violation of your constitutional rights is determined by the commissioners.
Yes, but not only that, Commissioner. Also because those recordings, it has been made clear in court that they are currently under investigation. So we do not know which part of the recordings are under investigation. So I cannot recklessly just answer a specific question, not knowing whether is it the one that is under investigation or not.
Perhaps if you could say slightly more, under investigation by who?
This was said in court, so I will assume that it's the same investigating officers that are investigating my current case that I'm attending in the Johannesburg High Court.
So they are also investigating these recordings?
Yes.
Could we request, perhaps, to your legal representatives to obtain that portion of the transcript?
Of course, yes.
In court, because I'm not sure I understand what you mean by the claim that the recordings are under investigation. So perhaps if we get the transcripts, I might gain a better understanding.
It's okay, we'll get the transcripts, but also during the disclosure, it was during the pre-trial actually. So when it was during the disclosure of the docket, and then we've noticed that there were no recordings there, and then my counsel requested for those recordings, and then the state advocate said no, they cannot issue us those recordings because they are a separate matter, they are under investigation. But as you said, we will get the transcripts and then it will explain everything.
And I think just so we don't talk past one another, we would appreciate those transcripts by tomorrow, so that when we resume tomorrow, we know what the actual position is. and how we engage with you on this matter.
That will be very hard for me to promise that I can be in possession of those things by tomorrow. Because, as you know, I don't have access to any. When I leave here, I'm going straight to CMAX, so I won't be able to make any telephone calls, but I will ask that after they adjourn here, then I at least consult with my legal counsel, and then I will ask them to get that on my behalf.
Hence, I specified that I think the request is more to your legal team through you, because I appreciate your position, but I would like to believe that your legal representatives are in a position to obtain the relevant transcripts that assist you in this regard and assist the Commission to understand how to deal with the matter of the recordings.
Yes, but also I would suggest, please, let it not be something that will be required the first thing in the morning, because obviously if you look at time now, they are going to request them tomorrow morning, maybe around 11, 12, then we'll be in possession of those transcripts.
Let me quickly raise a matter of clarity, Ms. Silo. If I did not misunderstand you, I thought you said something about the Commission making a decision on the question of the lawfulness or otherwise of the manner in which the contested evidence was obtained. I'm sorry. Or did I misunderstand you?
No, it's not. I don't say that. I say okay. In his affidavit,
yes,
he suggests that is an issue he's going to raise before yourselves.
Okay. Let me tell you my understanding. You'll correct me if I'm wrong. My understanding was that the decision that he says he's seeking is a decision that will be made by the court on the lawfulness or otherwise of the manner in which the evidence was obtained. And with us, he's then saying, until that has happened, the Commission should be barred altogether to traverse that terrain. So a decision on the lawfulness or otherwise is not one that should be made by the Commission.
Indeed, Chair, I agree with you. I was reading from his affidavit, which is what I had understood.
Yes.
Him to suggest in the affidavit, but I'll hasten to add that this is part of the legal argument and the points raised in limine that I understand perhaps are still to be argued before yourselves. So I would park that issue. Okay. But he had the affidavit seems to suggest that it's a legal argument to be made to yourselves. And there, Chair, you will see at paragraph 40, it says full legal argument will be made to the Commission on this issue.
Maybe we should not open that door. We should wait to hear if anybody will still raise that issue, because we are hearing the evidence now.
Indeed,
so maybe who knows? Maybe nobody will go back to that now that we are hearing the evidence. And Ms. Missy said what will be raised will be the question of the privilege.
And what I sought to establish here is the basis, because it's not articulated in the papers.
Yes.
And that's when Mr. Matlala raises the question of the recordings being under investigation. So that's what I was trying to tease out, to understand who's investigating and where he learned that from.
All right. Yes, Ms. Missy?
If I may, Chairperson, we wanted to address the issue with regards to the practicality of getting those transcripts, because what would happen is that the attorneys would have to put in a request from the transcribers, as I'm instructed, to obtain that recording from the courts. I forgot what the title is to the individual who does the recordings, and then obtain it, at which point would then get access to it. So to say that we'd have it by 12 o'clock tomorrow, perhaps it would be overambitious of us to assume that it's even practically possible. And if we make that undertaking, then it comes back and it may seem as if we're trying to frustrate the process, but practically it doesn't seem possible that we'd have it tomorrow. They are obtainable, it's just a matter of the timeline.
The timing, Unless things have improved significantly from the time I was last in practice, I think I agree with Ms. Missy on the practicalities.
I'm willing to accept that. I'm going to challenge her on that, except then there is a gap in the logic that is set out in the affidavit. So perhaps in the course of argument, we might be assisted with more facts to support what is set out in his paragraphs 84 to 86.
Thank you, Ms. Solo.
Thank you, Chair.
Chairperson, if I might make a suggestion that would try and aid and or assist the commission in moving forward whilst we wait for that recording, because there's an attorney of record who was present at those proceedings, would it be of any use for him to address that particular point, because he's heard what was said in the ruling or rather judgment made with regards to that? If it would be of any use, we perhaps could assist.
I don't think so, because this is a matter of evidence, and Ms. Silo is engaging Mr. Matlala at the level of testimony by Mr. Matlala.
The only issue I seek to establish, and I think it was triggered by Mr. Matlala's response, that the recordings are a subject of an investigation. So that's the only clarity I seek. Who is investigating? What does that mean, that they are subject of investigating, and who is investigating? And that is because when I engage Mr. Matlala on these issues, I will seek to persuade the commission that to the extent that they may be under investigation, that does not preclude Mr. Matlala from speaking on these matters, because it's the recordings, according to him, that are under investigation. It's not him per se who's under investigation. So I'll leave it there for the moment, Chair. When we come back, we perhaps will get better insight.
Mr. Maybe before you then move on, now that we seem to be agreed that we won't have the transcript anytime soon, then maybe let me ask my clarification question. Mr. Matlala, the investigation that you speak of into these recordings, is it by the state or by your legal representatives?
The investigation?
Yeah, you said that there's an investigation about these tapes or these recordals of you. Is it an investigation by the state or by your legal team?
By the state.
Is it by the state?
Yes.
And what in particular is being investigated about them? What was said is going to be investigated?
That is something that I don't know, but what I know is they just said that whatever has been I've mentioned in those recordings, for those things I'm being investigated. So I cannot tell what is it exactly what they're investigating there.
Okay, all right, thank you. And then lastly, at that paragraph 84, Ms. Silo, it's either a word is missing or a word that is there shouldn't be there. 84 reads, I have been provided with copies of any recordings of my interrogation, whether same in December, May.
I think of any other words that shouldn't.
Have you been provided with recordings?
Yes.
You have. Okay, so we must take out, I have been provided with copies of the recordings. That's how it should read. Thank you.
Thank you, Commissioner. That then will take us to your paragraphs 87 and 88. You are responding to paragraph 2.4 of the Regulation 10.6 notice, which required you to speak to the nature and extent of your relationship with the EMPD, including individuals employed therein, including agreements actual or negotiated with individuals within the EMPD, donation of vehicles and installation of use of vehicles fitted with blue lights, in particular who was involved, what the plan was, what became of the plan, and ultimately the use of vehicles fitted with blue lights and the use of peace officer cards. That's what was asked of you. You deal with that at page 17, paragraphs 87 and 88. If you could read those.
I have indicated above that I do not wish to deal with or answer any questions on this issue of EMPD. I refer to what I have stated above, and the statement are attached here to deposed to by Ntabise Nkodelia Kabeng.
And for the record, that affidavit of Ntabise Nkodelia appears at page 20 of the same file, your VMSA 1, correct?
Yes, that's correct.
And just to confirm, again for the record, this affidavit of Ntabiseng Cordelia speaks to the issue of use of blue lights only.
Yes.
Now, the question posed to you was at paragraph 2.4 was actually a compound question. There were other issues that are unrelated to the issue of the blue lights that you were required to speak to, but once again, you have failed to.
Can I comment on that?
Yes, please.
Yeah, it's not only the fitting of blue lights, it's any involvement with the EMPD, because I said before, last week Monday, maybe that's why it's not on this affidavit, that there are people who are currently facing criminal charges for not only the blue lights, it's peace officer cards and blue lights, and I think the donation. And as a result, also my name has been mentioned there. I heard the spokesperson of SAPS mentioning my name there.
So, in regard to these other matters, are you suggesting you are an accused or a suspect because you had your name mentioned? Are you able
not
to,
an
to
accused,
clarify?
Not an accused, I will say a suspect or a person of interest.
And as a matter of interest, in all these other cases besides the blue lights, which you have explained why you can't address, why do you consider yourself a suspect?
Like I said, there are people already who have been charged with those issues that you just mentioned.
And those people don't include you. So why do you suspect you're a suspect?
The investigation is mentioning my name.
Okay. We shall revert in time.
Maybe just to get confirmation, Ms. Kabeng says the investigation is by iPad. You confirm that?
Yes.
That she was interviewed by iPad and they told her they're investigating.
Yes, I confirm that.
Thank you.
We then go to your paragraph 88, still at paragraph 89, still at your affidavit starting at page 17, and there you are dealing with the contents of paragraph 2.5. And from paragraph 88, you then deal with your relationship with 4 other people. So if you could read the name of the person you, whose relationship you speak of, and then you deal with the contents of the paragraph immediately following the person's name.
I will start with Jotham Musibi.
Yes.
I knew Jotham Musibi purely as a person to whom I rendered security services. I never had business with him. I know Ignatius Motagati, Andrew Boy Mutetwa, and Katiso Molefe purely by virtue of the fact that I came across them and were introduced to them on occasions by Jotham Musibi, to whom I rendered security services. I never had any business dealings with them. I never sat around talking to them. I do not know any about their personal life or the business they are involved in.
Now, before you deal with the next person, at 89, you say you knew Mr. Msibi purely as a person to whom you rendered security services. I never had business with him. What do you mean by that last line, that you never had any business with him or businesses?
I will say I never had I attempted, yes, to do business with him, but it never materialized. So I never had any business without rendering security services with him.
And then while you are on that, what businesses did you attempt to have with him that did not materialize?
To purchase a private jet.
Yes. Any other?
No, it's only that.
Only that one?
Yes.
Were you then ever involved in any of his business dealings?
No.
Okay. Thank you. You then, from paragraph 91, at paragraph 91, deal with your relationship with the next person. If you could identify them and then read your paragraph 91 into the record.
Mike van Wyk. He was my business partner and is a witness in the Medicare matter. I am therefore exercising my constitutional right as an accused not to respond to or answer any questions pertaining to him or our relationship.
Now, he was your partner in the Medicare matter, and you say you are exercising your constitutional rights. I just want to understand, is this an exercise of constitutional rights in respect of any and all affairs of Medicare? Or is it only in respect of the SAPS contract for which you are currently facing charges?
Yes, only the SAPS contract.
Only the SAPS contract. Thank you. You proceed then to deal with the next person, and at paragraph, you identify them and deal with their relationship at paragraph 92, or your relationship with them.
Baron Mohoti, I have answered this aspect when I gave evidence.
So in effect, you're saying you've got nothing further to add to what you've already stated?
Yes.
Okay. Then lastly, I think at paragraphs 93 and 94, it's the last person.
Angwani Morgan Maumela and Suleiman Karim. My legal team is in the process of collating evidence in respect of the said persons which will enable me to move fully with awareness of an explanation of my rights, answer questions about them. I thus reserve my right to supplement this affidavit. I reserve my right to provide the Commission with any further and supplementary sworn statements necessary in these proceedings.
Can I just clarify paragraph 93? You say your legal team, quote, is in the process of collating evidence in respect of these persons being Mr. Hlangwani Morgan Maumela and Mr. Suleiman Karim, which will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them, end of quote. Can you say that in simpler English? What do you mean? I understand that they're in the process of collating evidence in respect of these persons, but I'm not sure I understand the remainder of that sentence. Are you able to assist? What do you mean that the evidence that they are collating will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them?
I think this is a typing error.
Okay, so I'm not that bad. Let's try and correct it. What did you wish to express?
Documents that will support that I do not wish to answer these questions because of self-incrimination. This morning I have managed to get a document that I already supplied to my legal counsel.
I'm not sure I understand. It's a very cryptic answer you've just given, so I'm not sure I understand.
What I'm trying to explain to you is,
Yes.
like the first sentence saying that I'm in the process of collating evidence.
Yes.
So maybe I was supposed to say documents that will prove that I'm a suspect and I'm being under investigation together with Mr. Maumela and also with Suleiman Karim.
Okay. So, okay, I think I understand. So then you say your legal team is in the process actually of collecting documents that will demonstrate and prove that you are a suspect. I take it in some alleged criminal wrongdoing, together with, not together, with Mr. Maumela and or Mr. Karim. Is my understanding correct?
With Mr. Maumela, Chairperson, sorry, Commissioner, if you can remember, last week I already touched on the Suleiman matter, and then you asked that I should bring an unsigned, what is it? An unsigned
loan agreement?
Loan agreement.
Yes.
So this is what I had that loan agreement, but I couldn't just find it. So what I had is only the document in relation with Mr. Maumela.
Okay, now, so you say that those documents will prove you a suspect. A suspect in what? Or which cases?
Suspect in, I think this money laundering, I think.
And that is in relation to both the persons identified there?
Only with Maumela.
Or with Mr. Maumela? And when can we expect these documents to be submitted? Because you say that your legal team is in the process of collating them.
They are already in possession of those documents.
Okay. I take it that they're in possession of the documents with a view to share with the Commission.
They will advise on that because they are under investigation. I don't know.
Or you just gave the documents to your
Chairperson, if I may be allowed to address the Commission in relation to that.
Yeah.
We couldn't just take it off word that he says that he's a suspect, and we needed to confirm before he would be able to make such an allegation of vermin before the Commission. And so he had to look for the document, which unfortunately, as I stated, he was unable to give it to us, the team yesterday. This morning he did give us the document, and it places us in a position where we can give, or rather he can make that statement on affidavit that he is a suspect and would be claiming his rights to privilege in terms of Section 3(4). Sorry.
Now,
is it to supplement, if I may, would need to supplement his affidavit so that he's able to make those averments and give you the correct facts.
So is it the intention of Mr. Matlala and or his legal representatives to share the actual document that demonstrates he's a suspect?
Ms. Missy?
Chairperson, the issue that we're having is that we haven't properly looked at the document to determine whether, to what extent he can claim his right to a privilege. So provisionally, I would say yes, provided that we get a timeline in which we are informed that the supplementary affidavit needs to be in at a particular time, and then it allows us to look into the document and determine there isn't everything that's privileged that disallows us to hand it over to the Commission.
Is there any problem sharing it with the evidence leaders right away?
Chairperson, I have not looked at it in detail. It's a document that immediately after we had engaged, we came down, he handed it over to me. I quickly glanced over it, so I can't answer that question definitively.
Is it a privileged document? Because if it is not, I would not understand why it cannot be shared immediately.
Chairperson, I suppose if you have to ask if it is a privileged document, I do not believe so, because the investigators would have a copy of it.
Then it should just be shared with the evidence leaders. So as you look whether there is a basis for claiming privilege, the evidence leaders will be looking at the document for themselves as well.
Noted. Share them on those bases. We should be able to share it.
It will be shared this afternoon still.
That's correct.
Thank you. Thank you.
Thank you, Chair. Thank you, Advocate Missy. I think it should, because as things happen in the Commission, documents become available and they are added to the exhibit bundle. So too, regardless of their source, so too shall this one. And this document is important. As a result, I'll have to park the issue I intended to raise in respect of 93. It's important because it would appear, Mr. Matlala, that you have adopted this posture regarding almost all the issues or the persons you've been asked about. If we go then, before I forget, that is the conclusion of the supplementation of his statement. You confirm that that paragraph 94 is the end of your affidavit.
Yes, I confirm.
So then you have given your supplementation. So then,
Ms. Silo,
yes.
I don't want to get ahead of you because it may be that you're still coming there. When I looked at 2.2 of the 10.6 notice read with Schedule 1, according to my reading, item 5, the person who appears as number 5, there's still not answer to the question in 2.2. Because 2.2 said, explain your history and or relationship, direct or indirect, with the listed law enforcement officials in Schedule A. And then when you go to Schedule A, it lists 28 people.
yes.
But on my reading of both affidavits, I thought it was an omission in the first one. And the second one was supposed to supplement. But I don't see in the second one where it deals with the name in item 5, unless I've missed it.
No, Commissioner, you haven't. Mr. Matlala, you understand we referred to Schedule 1 and the Regulation 10.6 notice, correct?
Okay.
We discussed the people listed in that document at page 7. And you will recall that in your original statement, when you, from page 12, you then dealt with, at paragraph 14, you dealt with a cluster of persons, 13 of them, from General Masemola to Major General Temba, about whom you said you will not be able to say anything regarding your relationship with them because they are your co-accused in the Medicare matter.
Okay.
From paragraph 15, you then dealt with some of the remaining persons on that list. You see that?
Yeah.
And there you dealt with Minister Mkunu, Patlane, General Patlane, General Mkwanazi, General Fani, and General Khan. You see that?
Yes, I do.
Now, in your supplementary statement, you then deal, or you purported to deal with the remainder of the persons you had not spoken of. And in this regard, as we looked at your statement, you, at paragraph 71, page 14, you once again deal with Minister Mkunu. You deal with former Minister Bekitele. You deal with, once again, with General Patlane at 15. You once again deal with General Mkwanazi. And you deal, followed by General Fani and General Koza. This is the affidavit we've just looked at. General Khan. He did sound. There has to be an explanation, Chair, somewhere on my papers there must be a Koza. I apologize for that, General Khan. So you deal with those at your paragraph 71, starting at page 14 of the affidavit. You see that?
Yes, I do.
Then we went further in your affidavit at page 18 from page 17 from paragraph 89, you deal with Mr. Msibi, the late. You deal with Mr. Van Veek, once again Mr. Mkhotsi, and then you deal with Messrs. Hangwani Maumela and Mr. Suleiman and Suleiman Karim.
Yes, I see that.
Now you confirm, if you go back to your annex Schedule A, that item 5 required you to speak about your relationship with Lieutenant General Shadrach Sibia. And the question posed by Commissioner Kumalo is that even in your supplementary statement, quote unquote, you have failed once again to deal with your relationship with General Sibia. You note that?
Yes, I do.
I think then perhaps this might be your opportunity to explain to the commissioners why you elected, notwithstanding that you were given a further opportunity to deal with that relationship in the terms as requested of you.
Oh, firstly, if we can remember, Commissioner, you asked me about, this goes to General Sibia, but I need to take you back. You asked me about my interactions with General Mkonazi. What was it that was discussed during the meeting? And I only told you about the Medicare tender and the warrant. So, and I said some of the things I could not talk about them because I wouldn't want to prematurely disclose my defense strategy. Because if you go back, and now I mentioned about General Sibia, and the very same recordings that I was talking about, his name has been mentioned there. And I said, those recordings are under investigation, and I do not know what actually are they investigating me about in those recordings. So I did not say anything about him because I did not want to somehow end up incriminating myself.
I think, Mr. Matlala, the question is, what is your relationship with this person? So it has nothing to do with offenses that are under investigation and the possibility of self-incrimination. You are being asked to explain your history and or relationship. Take Mr. Van Veek, for example. You've set out what your history and relationship is with him. Then you say, because he's a witness in the Medicare matter, you won't say anything further. But in relation to General Sibia, you don't even say you know him. You don't even say you have a history with him.
Okay.
And that is separate from whatever issues are being investigated and may be the subject of criminal proceedings. So I would expect you to please answer the question, what is your history and relationship with General Sibia? And then at a stage where you need to assert your privilege, you may do so. But I cannot accept that you are not even able to say, I know the person.
I understand, Commissioner. So I will say I know him because of at some point I went to his office to make a complaint about the occupation of the lease agreement that I had with Public Works. So that is the first time that I got to know of him.
The what of the lease?
The lease agreement, I had a lease with Public Works for the hospital that is situated inside SAPS College, which is in Pretoria West. So, and then I couldn't occupy that hospital. So that was my first time that I went to him to complain about that.
Perhaps to assist you, please let's go to the Regulation 10.6 itself, because specific questions are posted there in respect of each individual that is listed in Schedule A. So if you could consider all the questions set out in subparagraphs 2.2.1 to 2.2.7, can we invite you to answer each one in relation specifically to General Sibia? That might help Commissioner
Sorry,
Kumalo.
Commissioner, can you please clarify that again?
Please, let's go to the Regulation 10.6 in the same file that contains your statement. The first document should be the Regulation 10.6 notice.
Yes.
And if we go to page 3 of that file, At sub 2.2, it reads, explain your history and or relationship, direct or indirect, with the listed law enforcement officials in Schedule A attached hereto. In your response, you are required to provide the following information, and then it is set out in further subs 1 to 7 at page 4.
May I make this request, Ms. Sillo? Can you please read all those sub-paragraphs, but instead of individuals or officials, specifically refer in each instance to General Sibia?
I shall do so, Chair.
And then, so you refer to 2.2.1, we wait for an answer.
I shall do so,
all
Chair.
the way down. Thank you.
Thank you. So, but you have reacquainted yourself with paragraph 2.2. You understand what it requires of you.
Of course.
Yes. So then, back to Commissioner Kumalo's question, we are talking about your relationship now specifically with General Sibia, and we are going to consider each question in turn and have you speak and respond thereto, but confining your response only to your relationship with General Sibia. You understand?
I do.
Then the first question would be at paragraph 2.2.1, and then in this context would read, when and how did you meet General Sibia? If introduction was a third party, please provide the details of such a party.
When our 2023 or we still on General Sibia, right?
Yes, only.
Yes. It was in January, 2023 or 2024, I don't remember well.
Okay.
And then by how, I already explained how I met him.
No, you haven't. You say you met him when you went to raise the issue of the lease agreement regarding the hospital at the subs college. That doesn't speak to the how. So I'm sure if I tried to go to that office, they won't grant me access. How did you gain access there?
Okay.
How did you secure that meeting to get the opportunity to put your gripe to him? Why did he entertain your visit? That's the kind of detail required. So if you could help us with that.
Yes, it's because I sent him an email.
Okay.
And then requested for a meeting. And his email address was given to me by Sergeant Nkosi.
Yes.
That's, I think that will answer by a third party who made the introduction.
So it was Sergeant Nkosi who made the introductions?
Yes.
Okay. The second then is at 2.2.2, the nature or description of your relationship with General Sibia.
I do not have a relationship with him.
Maybe not now, but let's say from the date you met him until the date of your arrest. What was the nature of your relationship with him? The description, nature or description of your relationship?
I do not know how to answer this question, Commissioner. You say nature.
Were you friends?
No.
So your engagements with him, what were they? Were you engaging with him as a policeman, as what?
The engagement, hence I said, is something which is under investigation, which I cannot.
The nature of relationship. Staying then with the regulation 10.6 at 2.2.3, page 3, that's where I'm reading. The 10.6 required you, in respect of General Sibia, to explain the nature, extent, and frequency of your communications with him.
Communications, it was maybe once when I went to his office.
Okay. And by communications, direct or otherwise? Have you communicated with him directly, and have you communicated with him indirectly? When we talk about indirectly, please explain the method of communication you conducted then.
Directly, yes, through, I sent him an email.
Yes.
That was the first time. I've never called him directly. So I only spoke with him, I think, I'll say 3 or 4 months. I'm just saying on top of my head, I cannot remember well. Maybe I'll say 3 or 4 months after I first met him. And then the communication then was through a third party, the very same Sergeant Nkosi.
And how frequent was that communication?
Frequent, plus minus 3 or 4 times.
And what was the communication about?
Let's leave it there because that is part of the investigation.
Is the engagement party you attended of his daughter or son, are you seriously suggesting it's part of IDEX investigation?
Yes, it is.
In what manner? As to who engaged who and why, or why?
I think I'll have to discuss with my legal counsel because I'm in possession of my 204 statement. The only way for you to understand that is for you to see the statement, but it is.
I think then it would help for the commissioners to understand the basis on which you seek to assert this right? Because the attitude you are adopting is you cannot ask me about General Sibia because IDEC is investigating something somewhere.
But Commissioner, fairly speaking, I have to go to court and account on this, so I cannot now ventilate anything that is to do with him, especially something that is already being under investigation. I do not know even whether he will be charged or not. So chances are he might not even be charged. I don't know that. But currently myself, I'm charged, and I have to go to court and account for these things. So I don't think it's fair for me now to speak about something which I'm not sure at the end of the day whether I'll have to account for that or not.
You see, the challenge I have, Mr. Matlala, is I think you conflate yourself with General Sibia. You are not General Sibia. You are facing charges for your conduct. And we haven't done anything to even stray into that discussion. We're talking about something separate, which is your relationship with yet a third party who's not charged with you. So I don't understand, in the current criminal case that you are facing, how you'll be called to account for your relationships with, including General Sibia. How does that come into play?
It actually does.
How?
I don't know how because I'm not an investigator.
Okay, then I'll tell you that it doesn't. You cannot even, I won't even say prove, it's too high a threshold. You cannot even persuade the commissioners that it is relevant for purposes of the current criminal case you are facing. You are not able to. You accept that?
I do not accept that.
Okay, then if you don't accept that, then demonstrate to these commissioners that relationship is relevant to the charges you currently are facing.
I think I've just said it that the only way for me to demonstrate that is for me to now to get right inside the cracks of the matter, which is something that I cannot do.
Then I'll put this proposition to you, that you don't want to talk about the nature, extent, frequency of your communications with General Sibia, because if you do, you are at risk of incriminating yourself in some offense, because by their very nature, they would be breaching the law. That's my proposition to you. What's your response?
I cannot argue with you on that.
Okay.
That's how you see it.
Then,
Sorry, before you move on, Mr. Matlala, in describing the nature of the communications with General Sibia, you have a number of options, and without getting into the detail of it, and I don't intend to repeat what Ms. Silla has said to you, because ultimately the Commission must be satisfied that you have correctly asserted the privilege against self-incrimination. And for us to do that, we need to know what it is that you avoided talking to, not in general terms, general broad terms, but specifically. Having said that, when I say you have a number of options, I can put this to you as an example. You have had interactions with General Sibia. We know you sent an email, you went to the office, and you do say it had to do with the lease. I think it's competent to ask you, have you had any interactions with him about the Medicare contract, still at general terms? And if you're asked what exactly, you can say, I wanted help to resolve the lease issue. You testified in the ad hoc committee, for example. You said you interacted with him about the kidnappings of, I think, Mr. Bushocha and Mr. Dikale. That has nothing to do with your Medicare contract. And if you don't speak to that, then you are not being frank with us. If you don't say, well, other things that have nothing to do with the Medicare contract I've dealt with him, then you're not being frank with us. The chairperson said to you, asked you, have you socialized with him? And it had to be put, it had to be dragged to you, in my opinion, for you to say, yeah, we had an engagement. So there are topics that demonstrate or would explain and say something about your interactions with General Sibia, and they have nothing to do with Medicare. And there's no basis or valid basis for you not to speak to those when you're asked to explain your interactions with General Sibia.
I think also what Commissioner Balwe is referring to, I think we have had sight of the ad hoc committee transcript. If I'm not mistaken, I think it's in that transcript where you say, in fact, you contradict what General Sibia said before us here. You say you attended the engagement function, and that you did not go there just to pick up your wife, which is what General Sibia told us. You say you attended that, and as I understand it, you attended as an invitee, and you were there for a period much longer than just going there to pick up your wife. So I'm raising that in support of what Commissioner Balwe is saying, which is there is a lot you can talk about, and I do not see how it's incriminating for you to tell us that you went to the engagement party and also to contradict General Sibia on what he himself said about your attendance there.
Thank you, Chairperson. Chairperson, it's not only the Medicare tender. Like I said before, it's also the contents of the recordings which are also putting me at the risk of self-incrimination. So I do not know how is the approach of, I cannot tell now as I sit here what is the approach of the investigation. I do not know that. So when I testified in the ad hoc committee, by then I was not yet charged or even being under investigation. So now it's a different thing now. I'm charged and I'm also under investigation.
You have only two bases on which you assert that privilege. You are either an accused or you're a suspect. There's no all-encompassing protection or umbrella that you say, well, I know it's being investigated and I don't know which way it will go. That's not what that protection that is given to you is all about. On this issue, this very issue, and so I shouldn't be required to speak to it because I'll self-incriminate. That is the easier part. The other is, I'm a suspect. But even there, you have to provide details because, as Ms. Sillo says, it's not your say-so. You don't just say, I'm a suspect, and that's the end of it. We are entitled to engage you to establish that indeed you are a suspect. Because if you're a suspect, of course, we have to be careful what we ask you if you are asserting that privilege and how we engage with you. So those are the two topics. That something is in the recordings is not sufficient to invoke that protection for you. You can't simply say, well, it's in the recordings and those recordings are being challenged and I don't know how they are going to use those recordings, therefore I should not be required to answer those questions. I think you can accept that if the privilege is properly invoked, if you rely on it properly, on the correct facts, the commissioners will give it proper regard because we wouldn't want to impinge on your fair trial rights. You can accept that, but the burden is on you to show us that an answer to a particular question will tread into your fair trial rights, and we must respect that. So far, you're speaking in you're dealing with matters in very broad and general terms, and that doesn't avail you. It's not available to you. But more importantly, you are either a suspect, and you have to show why you say you're a suspect in a particular matter, or you're an accused. Those are the only two circumstances. I don't know if you want to comment.
Yes, I wish to, Commissioner. I said I will make sure that I get the transcript from the pre-trial to prove that I'm actually a suspect in those recordings. And I will say again that in those recordings, I did not know to be careless by saying something that will later incriminate me. But that is a fact that I am under investigation for getting those transcripts so that you can...
Do you accept that we have to have those transcripts presented to us? They must be engaged upon with you. They must be before us. You must look at them. We must engage with them in order for us to agree with you on any item. It's not everything that's in the recording. I take it that you say is untouchable. But even if that's what you're saying, that everything in that recording is untouchable, you do accept, at least I think I understand you, to accept that those recordings would have to be before us, and then to engage with you when you say, that part, if I deal with it, I'm self-incriminating. You accept